Good afternoon. This is the Public Service Company of Colorado gas rate case, 24AL-0049G. Any preliminary matters? My understanding is we're about to put on Mr. Freitas, uh, Ms. Brahma. Preliminary matters.
We have none today, Chair Blank. Thank you very much. Mr. Freitas is ready and on Zoom.
Let me, if Freitas or Freitas, sorry.
It's Freitas.
Freitas, all right. Commissioner Plant, Commissioner Gilman, any preliminary matters before we jump in?
Nope.
Nothing.
All right. Mr. Freitas, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Is anybody in the room with you or communicating with you in any way?
No, they're not.
That changes, you'll let us know.
Absolutely.
All right. Ms. Brahma, back to you.
Thank you. Good afternoon, Mr. Freitas. Could you please state and spell your full name for the record?
Yes, my name is Arthur Freitas, ARTHURFREITAS.
For who do you work and in what position?
I work for Xcel Energy Services Company as the Director of Revenue Analysis.
And did you cause to be entered into the record in this proceeding and filed your hearing exhibit 117 and attachments, direct testimony, and 136 with attachments, your rebuttal testimony?
Yes, I did.
Do you have any additional corrections to your testimony today?
I do not.
With that, Mr. Freitas is available for cross-examination.
Thank you, Mr. Bunker. I have 60 minutes.
Thank you, Mr. Chairman. And you may recall I had some moments, about 15 minutes left with Mr. Delsich, I believe it was, that I transferred to Mr. Freitas. So by my count, I have 75 minutes.
Oh, I gave them to Ms. Crampton yesterday for Mr. Piquet, but all right. But it'll be a hard cutoff at 75.
Okay, thank you for
All
that.
right.
I will do my best. If I have to plead for another couple of minutes, I will when we get there. Thank you.
All right, let's try. We're struggling to hit the schedule, so
I understand. I understand. We'll try to make this as quick as possible, won't we, Mr. Freitas?
We will do
Freitas.
our best.
And it's I'm sorry, it's Freitas, correct?
That's correct.
Freitas. All right. I'll try to keep that in mind. Thank you. If we could refer to your hearing exhibit 136, this is your rebuttal testimony. And if we could go to page 18. And starting on line 7 through 11, here you're talking about the growth in PSCo's rate base, correct?
What lines were those again?
7 to 11.
Okay.
And you're talking about public services growth and rate base, right?
Just in general, yes.
Okay. And is it your understanding the Colorado legislature is concerned about the growth and rate base of Colorado's regulated gas utilities?
Well, this section of my testimony, I'm just making general statements about the increase in all the people moving to Colorado and the increase in population and development. So I'm not specifically referring to anything that the Colorado legislature has said or is concerned about.
Okay, that's fair. Is it your general understanding that the Colorado legislature is concerned about growth in rate base of Colorado's regulated gas utilities?
It's kind of a general statement. Is there a document or something that you could refer me to that would show that statement by the legislature?
I'm just talking about your general knowledge. For example, the last couple of years, there have been several uh, House and Senate bills passed, and I'm just asking your general perspective.
Well, I don't know that I have a perspective. I'm not up at the Capitol and not really paying attention to what uh, comes out of the legislature in general. There's something that's specific to rate making, then that would catch my attention. But general statements by the legislature, I don't know that I can really speak to what they have or haven't said.
Okay. Let's look back here at these lines on 7 through 11 on page 18. And if public services gas customer count stops growing, will that lead to flat or decreasing plant year over year?
It's a little bit hard to answer that question just based on that hypothetical, because changes in depreciation rates and there's lots of factors that go into plant additions and plant retirements. So customer growth is one of them, but not the only one. So I don't know that with just that information, I can really say what would happen to rate base or gross plant service.
Okay, we'll come back to this topic, but let me ask you to look at page 5 of your rebuttal testimony on lines 1 through 8. And here you indicate information regarding the company's rebuttal cost of service, which includes minor corrections as well as certain updates and adjustments as compared to our initial case. That is one of the purposes of your rebuttal testimony, right?
Correct.
And at lines 4 through 8, you indicate that in the rebuttal case, Piesco agreed with recommendations from UCA and staff, and the rebuttal cost of service reflects a 2023 calendar year, including 12 months of actual data, albeit with a year-end rate base. Is that right?
That's correct.
Okay. And so to be clear, the company's rebuttal cost of service and what you refer to in some places as the updated 2023 test year, that is a historic test year, or an HTY, ending December 31, 2023, which includes 12 months of actual data. And this compares to well, let me just ask, is that correct so far?
Yes.
Okay. And this updated 2023 test year that we just talked about, ending December 31, 2023, that compares to what Piesco filed in its direct case, which was a test year consisting of 12 months ending December 31, 2023. But it was based on actual capital investment through September 30, 2023. And then the last 3 months were forecasted capital additions through December 31, 2023. Is that right?
For the capital, yes. O&M and revenues, essentially all of the other components of the revenue requirement besides capital were based on actual data through September 2023.
Okay, so all of it was, in other words, the first 9 months was actual data, and the last 3 months was forecasted data, whether it be O&M, capital additions. Is that right?
No, let me try this again. So the test year in the direct case, so APF attachment APF 1 was actual data through September of 2023, for all components of the revenue requirement. And then for just capital, there was an adjustment to bring in 3 months of forecasted data. So only capital is what had any amount of forecast in it. Everything else besides capital was based on actual information through September.
Okay, thanks for that clarification. And is it correct that while accepting UCA and staff's recommendation to use an HTY ending December 31, 2023, with 12 months of actual data in the company's rebuttal case, Public Service rejected UCA and staff's recommendation to use the 13-month average rate-based methodology. Is that right?
That's correct. And there's a large section of my testimony, rebuttal testimony, which I'm expecting we'll get to, that discusses why my opinion is that year end is more representative for this rate case.
Yep, we'll get there. If we could take a look at Mr. Skluzak's hearing exhibit 500, this is Mr. Skluzak's revised answer testimony. And if we could go to page 40. Starting at line 17 and then on to page 42, you will see or 41 rather, you will see a colored table. See that?
I see it, yes.
Okay. And in this testimony, starting just at the top or the bottom rather of page 40 on line 17, Mr. Skluzak talks about the fact that there are numerous revenue requirements that Piesco either presented in its direct case or provided in discovery, and that he has put together a table that summarizes that, the various revenue requirements, and that is table CWS1. Do you see that?
I do.
Okay. So let's focus on CWS, table CWS1. And oh, excuse me. And in this, I see 6 different revenue requirements and other data presented by Piesco in its direct case and in response to UCA and staff discovery requests, right?
Yes.
Okay. And as I looked through your rebuttal testimony, I could not find a reference to Mr. Skluzak's table CWS1. So is it accurate to conclude you agree with the summary of the information that's in table table CWS1?
I'm just looking real quick at the amounts in the table. They appear to be a accurate representation of the amounts in those test years or cost of service models.
Okay, thank you for that. And as reflected in this table CWS1, well, let me back up one moment first to this. Is it your understanding that UCA witness Mr. Skluzak and staff witness Ms. Grabegzabir, and I hope I pronounced that somewhere close to being right. If not, I'm sorry. Each attached Piesco's corrected response to CPUC 1-31 and corrected attachment CPUC 1-31.A2, which reflected the updated test year model with a 13-month average rate base to their respective answer testimonies. Is that your understanding?
I know that Ms. Gabregzabir did attach both CPUC 1-31.A1 and .A2, which are the in this table, the two bottom lines. So the 2023 full HTY on a 13-month average and year end. I know that she attached those to her testimony. I can't recall if Mr. Skluzak did.
Okay, well, we're talking about his testimony here, so you see the references you just pointed out in the red line and then the green line, or the green part of the chart at the bottom, that here there's a reference to CPUC 1-31, and in the red it is .A1, and in the green it is CPUC 1-31.A2. Agree?
Yes.
Okay. And just to clarify for those who might not be aware, the attachment CPUC 1-31.A2, that is the full 2023 HTY using 13-month average rate-based methodology, right?
That's correct.
Okay. And we see when we look at the green column there, and we look to the left, that's what it shows in the first two columns there, the test year and 13-month average in the second column, right?
Yes.
Okay. And then just to further clarify, attachment CPUC 1-31.A1, that's the full 2023 HTY, but that uses the year-end method. Is that correct?
Correct.
Okay, and that's what you and public service rely on in your rebuttal case, is the version of the attachment .A1, the year-end method, right?
Correct.
And what staff and UCA are relying on is, in the green, the attachment CPUC 1-31.A2 using the 13-month average, right?
Correct.
Okay. Now, is it your understanding that Mr. Fernandez's attachment RAF2, which is the UCA's revenue requirement model, that it used as its starting point Piesco's corrected discovery attachment CPUC 1-31.A2 with 13-month average rate base?
That's my understanding, yes.
Okay. And if we look at the last line on the bottom of Mr. Skluzak's table, CWS1, the shaded, the column or the line shaded in green, the updated 2023 test year model with 13-month average rate base yields a revenue deficiency in that last column of about $152 million, right?
Yes.
And if we could, for just a moment, go to your rebuttal testimony, but keep this table handy, please, Ms. Frederico. If we could go back to your rebuttal testimony at page 7, on lines 12 through 17, here you indicate the starting point for the rebuttal cost of service is the revenue requirement model provided in discovery through the supplemental response to CPUC 1-31 and specifically attachment CUPC 1-31.A1, which updates the test year model with a year-end rate base, right?
Yes.
So that just kind of confirms what we were just talking about with regard to this table in Mr. Skluzak's testimony, right?
Yep, I agree.
Okay. Now, if we could go back to page 41, excuse me, and table CWS 1. And if we look at the red shaded area in the row second from the bottom, this shows the revenue deficiency using the full 2023 test year, with year-end rate base is about $170.2 million, right?
Yes.
So when we compare the revenue deficiency there in the red of the 170.2 million to the green, which is the full 2023 HTY using 13-month average, the difference is about $18.2 million between using year-end rate base versus using 13-month average rate base for the updated 2023 HTY, correct?
Yes.
Okay, a question for you regarding at the top of the table, and it would be the fourth column from the right, and the acronym EGS on rate base. And is it correct that that is earnings on rate base?
We could scroll down to the footnote 40, I think it is. Yes, that's what Mr. Skluzak has indicated EGS means.
Okay, thank you. And so the difference in earnings on rate base between 2023 using the updated HTY with year-end rate base versus 13-month average rate base is about $16.4 million, right? And by that, I'm looking at 314.4 million minus 298 million, and I come up with 16.4 million. Is that right?
Yes, I agree with your math. I do want to make a clarification, though, that I believe that that column that we're talking about, which is labeled as earnings on rate base, is in fact return on rate base, which is different than earnings, because the return on rate base includes the return to debt holders, whereas as I think of earnings, I think of that as the return to equity holders only. I just want to make that clarification, just so that we're clear that I believe that that column is return on rate base as it is shown in my revenue requirement models.
Okay, that's a helpful clarification. And so the difference of 18.2 million versus the $16.4 million here in this return on rate base column was about $1.8 million, right?
I'm sorry, could you repeat that? I kind of lost you.
Sure. I'm looking at the revenue deficiency in the far right, 170.2 versus 152, and that difference is about $18.2 million, right?
Yes.
And then what we just talked about, this being return on rate base, the difference or the solution there, the sum, is about 16.4 million. So the difference between those two sums is about $1.8 million. Agree?
Yes.
Okay, so what is the overall difference, or what is the remainder difference of $1.8 million if it's not due to earnings? What would that be?
That would be the second to the column second to the right, which is base rate revenue. Sorry, that's the revenue requirement. The column that is not or the amount that is not shown that is accounting for that difference is base rate revenues, so revenue at present rates. The revenue deficiency is defined as the revenue requirement, which is shown in the column second to the right, minus revenue at present rates. That column is not shown on this table, but that column would be the difference between the return on rate base amounts and the revenue deficiency amounts.
Okay. And as we just went through this, we came up with or let me ask you this. Let's go to your rebuttal testimony on page 20. And at lines 18 to 19 on the bottom of the page, here you indicate the impact of applying average rate base instead of year-end rate base is approximately $18 million, right?
Correct.
And as it relates to the rates to be paid by ratepayers, a commission decision to use the 13-month average rate base method rather than the year-end rate base method is a decision point with a value of approximately $18 million in this proceeding. Is that right?
That's correct.
And this $18 million in less revenue would incrementally affect the affordability of public services gas service to its ratepayers. Is that correct?
Objection vague as to the definition of affordability.
And
Overruled. I'll let the witness answer.
I'm not sure how you're defining affordability. I don't discuss affordability at all in my testimony, so I'm not quite sure how to quantify that measure.
would you agree that if the charge to ratepayers is $18 million less, that would be a benefit to customers?
I'm just gonna object. This is outside the scope of Mr. Freitas's testimony.
I think overruled. He can answer.
I would say not necessarily. The price that customers get charged would be less, but that doesn't take into account the value that they receive for what they're buying, which in my opinion is part of what constitutes benefit.
Okay, let's move on. If we go to your page 11 of your rebuttal testimony, here you indicate Piesco's rebuttal case using what you refer to as the updated 2023 test year is approximately $169.6 million on line 9. Is that right?
That's correct.
And if we could go back to Mr. Skluzak's table on page 41, and the third row from the top, let me see. The third row from the top for the revenue deficiency, this was the direct case filed by Public Service, using the year-end proposal or year-end rate-based method. That revenue deficiency was $170.7 million, right?
That's correct.
And so the rebuttal case only reduced the company's revenue requirement and revenue deficiency request in this proceeding by about $1.1 million. Is that right?
It's about right. Yeah.
Okay. Okay, let's go back to your rebuttal testimony at page 17. And on lines 10 through 13, here you argue the decisions this is about rate-based methodology. And here you argue the decisions that establish the criterion for when it is appropriate to use year-end rate base are decades old. Is that correct?
Yes.
In in these same lines on particularly 12 through 13 on page 17, here you criticize that staff in UCA selectively point to decisions from the last 10 years to support their argument for average rate base. Is that correct?
Yes.
Okay, let's go to the next page, page 18. And with that criticism about the last 10 years in mind, I'd like you to refer to your question on lines 18, on page 18, lines 4 through 5, where you say, please summarize the conditions in which public service is currently operating. Is that right?
Yes.
And then under that question, there are 4 subsequent paragraphs starting at 18, page 18, line 6 through 19, line 8. And here you discuss Piesco's current operating conditions, right?
Yes.
Now, again, with in mind the criticism about the last 10 years, which you referred to regarding staff and UCA, here on line 6, you start your answer with over the last 10 years, and then you discuss Colorado's dramatic increase in population that's contributed to growth in rate base and requests for gas service, and the need to make investments, and that over that same 10-year period, interest rates and inflation have remained low. Is that right?
Yes.
Then
Wait.
in the next paragraph, starting on line 12, here you say, more recently, and then you discuss economic and policy conditions that have changed substantially. And you indicate interest rates and inflation rates are substantially higher than what was experienced over the past 10 years. Is that right?
Yes.
And then if we go to the next paragraph on line 16 and 17, here you state, in addition to the state's policy goals have shifted to encourage electrification and reduce the growth in gas system. And is it correct to conclude this statement also focuses on the period over the last 10 years? Would that be a correct conclusion?
No, that statement starting on line 16 is more referring to what's happened more recently with state policy goals shifting, going into the future to encourage electrification. That hadn't really happened over those past 10 years, but that's more starting more recently and going forward.
Okay. So when I started this cross-examination with you, I asked you about your view on, is it your understanding that the Colorado legislature is concerned about the growth and rate base of Colorado's regulated gas utilities? But here on page 18, starting at line 16, you're talking about state policy goals, right?
As it pertains to climate control or climate change control and electrification.
Okay. So after criticizing staff and UCA for looking to the last 10 years to support their argument for average rate base, you then rely on 2 decisions from 1974 and 1975 in your rebuttal testimony, starting at page 31 on line 7. Is that right?
So in this section of my testimony, I provide a little bit of background on how the commission has historically thought about earnings attrition in the context of whether to approve a year-end versus average rate base. And based on the the decisions that I looked at, which were basically all of them from the last rate case through this one, these two decisions appeared to provide the most information on context in terms of how commissions have historically thought about year-end rate base and the conditions when that is appropriate to approve year-end rate base. So I'm not specifically relying on these two decisions more. These are the two decisions that seem to provide the most information about how the commission has historically thought about average versus year-end rate base.
Do you happen to know how the commission ruled on the 13-month average versus the year-end rate base issue prior to the 1974 decision that you cite?
I do not.
And would you agree that if the commission consistently approved a 13-month average prior to the 1974 decision that you cite and rely on, would you agree that the history before 1974 is just as relevant to the rate-based method discussion as are the 1974 and 75 decisions?
I think the point of this section of my testimony was not to recite what the commission did, but more to give the context of why they did what they did back then. And so I guess I would answer that question to say, to the extent that those decisions provided more context to answer the question of why, and to explain the conditions, the economic conditions that existed at the time, and why those conditions justified or didn't justify year-end rate base. I think that would be helpful, but simply just saying, well, the commission did this back in 1965 doesn't really provide me with much information because it lacks the context of what was going on at that point in time.
Okay. So you did not attach either of these decisions to your rebuttal testimony, is that right?
I did not.
And when the UCA asked you to produce these two decisions in discovery, Piesco did not provide them and instead directed UCA to go to the PUC's Google Drive and find these public documents themselves. Is that right?
These were publicly available documents that were equally available to both public service and UCA.
Okay, let's pull up hearing exhibit 549, please. Out of box. And you will see that this document is PUC's response to UCA discovery request number 36-13. And I direct your attention, Mr. Freitas, sorry about that, to the bottom of the page, and you are listed as the sponsor of this discovery response, correct?
Yes.
I'd move to admit UCA hearing exhibit 549.
No objection.
So admitted.
Okay. Thank you. So we see in the response there that you indicate the decision can be publicly found from the decision volumes link on the Public Utilities website at decision volumes-Google Drive, right?
Yes.
And so, Mr. Freitas, I will represent to you that UCA followed your instructions, and I'd like the court or Miss Frederico to pull up UCA hearing exhibit 548, please. And I will represent to you that this is the Colorado PUC decision number 85724 in investigation and suspension, or INS docket 868, and it's dated September 24, 1974. Do you see that at the top there?
Yes.
And I will represent to you that this, and we can scroll through it, but I will represent to you first. This is a 56-page PDF document that consists of decision number 85724 and its appendices, which are pages 1 through 38 of the PDF. The errata to the decision 85724 at pages 39 and 40 of the PDF. The dissent of Commissioner Henry Zarlingo to decision 85724 at pages 41 to 45 of the PDF. And then Appendix A to the dissent of Commissioner Zarlingo, which in turn is a further dissent by Commissioner Zarlingo to decision, and that is pages 46 to 56. So that is the entire 56-page document. Now, let me ask you a question regarding something you state on page 31 of your rebuttal testimony. And here on page 31, starting at line 8, you discuss this decision number 85724. And then you have several quotes starting on lines, you indicate this is where the quote's coming from on line 9, and then the quotes on 11 through 13, on down through the bottom of the page, and on to page 32, line 14. Is that right?
Yes.
And would you agree that given there was a dissent to decision 85724, that this decision you cited was a non-unanimous decision?
I guess that would be what a dissent would indicate.
Okay, thank you. I would move to admit UCA hearing exhibit 548, the administrative notice under Rule 1501C.
Sprama?
I have no objection to the concept. Again, though, I just would like to have the opportunity to make sure that it's a complete document.
Let's admit it, subject to a review by Ms. Brahma. And if we don't hear from you, we'll assume it's good. If we do, we'll take it up then.
Thank you.
Thanks.
Thank you. If we could move to page 11 of hearing exhibit 548. And you will see at the top of the page, there are some numbered lines 8 through 13. And what I want to focus on is under the numbered line 13, the second paragraph below it. It's the paragraph that states, for those familiar with past commission policy. Do you see that line?
Yep.
Okay. And here you'll note that the commission states, for those familiar with past commission policy, it will be noted that today we have departed from past commission policy in two significant respects. That is the adoption of a year-end rather than average rate. Do you see that?
I do.
Or that's average rate base. I'm sorry. I cut off the last word, rate base. And did I read that correctly?
You did.
Okay. And as we talked as we started, this is a decision that's dated September 24, 1974. Is that right?
Yes.
So, given the commission's statement that it was departing from past commission policy to adopt a year-end rather than an average rate base, would you agree that prior to September 24, 1974, the commission's policy was to approve the average rate base method in rate cases?
I would agree that at least for the case before this one, that rate base was average rate base was likely approved. And then in the next paragraph, the commission goes on to explain why. In the next two paragraphs, which are the ones that I cited, it goes on to explain why the commission departed from its decision in the case prior to this one.
Yes, and we will get there. Thank you. Would you agree that the commission's history on this rate-based method issue prior to September 24, 1974 is just as relevant as your citations to the 1974 and 1975 decisions in considering the commission's history on this issue?
I'll object just because this question has already been asked and answered.
Mr. Bunker, you want to rephrase a little?
Sure. Let's just move on to the next question I have, which is the third paragraph here on this page, the middle of the page. It's the short two-line sentence, and here it says, with respect to year-end rate base, the economic conditions of attrition, inflation, and growth lead us to conclude that it should be adopted. Is that right?
You read that correctly, yes.
Yeah. And would you agree the commission did not use the word or, but instead use the word and for these three economic conditions?
The word and is in there, yes.
Okay, thank you. And if we could go to the page 12, the third full paragraph, which is about the middle of the page. It starts with the word accordingly. Do you see that?
Yes.
On page 12. And it reads, accordingly, we find and conclude that the threefold factors of attrition, inflation, and growth more than justify and indeed mandate the use of year-end rate base in this proceeding. Is that right?
That's what it says, yes.
Yeah. And with respect to the inflation factor mentioned here in hearing exhibit 548, do you agree that just today, the Bureau of Labor Statistics reported that the consumer price index for August increased 0.2% for the month, which was in line with the Dow Jones consensus, and that inflation in August declined to its lowest level since February 2021?
I have not looked at the financial news this morning, so I don't know what has been reported.
So you have not looked at any news regarding the inflation report that was released today?
I have not.
Okay. Let's go to Mr. Skluzak's answer testimony. Attachment CWS 29. And here you will see that this is I will represent to you that it is an excerpt from Mr. Skluzak's testimony in the 2017 public service gas rate case. And if you go to page 2, you will see that here his discussion is regarding average versus year-end rate base for the 2016 HTY. Do you see that?
I do.
And if we could go to page 4 of this PDF document, and you see here on lines 4 through 12, here Mr. Skuzak discusses the 1974 rate case that we were just talking about in hearing exhibit 548. And he states the specific, starting on line 5, the specific context of the 1974 case was there was rampant double-digit inflation, and Piesco Electric was installing pollution control equipment on generating stations which would not produce associated offsetting incremental sales revenue. Did I read that right?
Yes.
Okay. Do you have any reason to dispute that discussion by Mr. Skuzak there regarding the 1974 case and the specific context of the case?
I will note that the order that we've been talking about doesn't talk about rampant inflation. It talks about inflation.
Okay.
So I don't know that I agree or disagree with this with his characterization, but I will note that rampant double-digit inflation does not appear in that order.
Okay. Let's go to Mr. Skuzak's answer testimony in this case, which is hearing exhibit 500. And on page 71 at lines 1 through 7, and in footnote 92, he states he's quoting from the commission's 2019 decision in Public Services 2017 rate case. And as you can see at the top of the page there on lines 3 through 5, and it's highlighted in bold in that in his testimony, the commission notes its historic reliance on these 3 factors: earnings attrition, inflation, and capital growth. See that?
I do.
Okay. So would you agree that with respect to the historical use of certain factors which have been enumerated as attrition, inflation, and capital growth, that as recently as the 2019 decision in the 2017 rate case, the commission indicated these 3 factors should be present to support the use of year-end rate base?
I do agree, actually, and my rebuttal testimony goes on to talk about the evidence that has been presented in this case for attrition, inflation, and capital growth. So I agree that those are the conditions that the commission historically has looked at. Okay,
thank you. Now, if we could go back to hearing exhibit 548, and this is the decision from 2017, or I'm sorry, 1974. And if we could go to page 43, please. And I see you're there. Thank you. And this is from the dissent of Commissioner Zarlingo. And if we actually scroll up, if we could, for just a moment. We see that starting on page 41, at the top there, you'll see that the words "I respectfully dissent," and it then shows a signature block by Commissioner Zarlingo on page 45. So I just want to make it clear that this is Commissioner Zarlingo's dissent to the decision. Okay. So if we could now go back to page 43. And you will see, let me see if I can easily spot where I'd want to focus your attention. And that is under the Roman numeral 3 on the bottom half of the page. Commissioner Zarlingo states, the commission has shifted from the use of an average rate base, in parentheses, only so recently as February 23, 1973, decision 82411, established and determined by the commission to be proper and legal base for determining rates to a year-end rate base, apparently to suit its purposes, as the reason for justifying this change remains vague and is unsupported by any competent and factual evidence. And I realize that it appears to me there's a word or two missing here and there, but did I read that correctly?
Yes.
Okay. All right, thank you. Let's go to your rebuttal testimony. That's hearing exhibit 136. And let's go to page 17. And on lines 8 through 10, here you indicate parties have argued that regulatory lag is beneficial to customers and that special circumstances need to exist in order for year-end rate base to be appropriate. Is that right?
Yes, that's what it says.
Okay. And so let's break this sentence down, if we could, into two separate issues. The first is regulatory lag, and the second, special circumstances. Okay.
Okay.
Do you agree that regulatory lag is beneficial to customers?
To a certain point, but then too much lag, as I mentioned in both my direct and rebuttal testimony, that too much regulatory lag can make it essentially impossible for a utility to earn its authorized return.
Okay, and if we turn to page 22 on lines 3 to 5, here you say, or argue that regulatory lag is not an incentive to control costs if the costs are beyond the company's control. Is that correct?
It's not the strong incentive.
Okay. And what evidence are you aware of that Public Service has placed in the evidentiary record that would support an argument that its costs are beyond the company's control?
Well, as I mentioned later in my rebuttal testimony, any investments necessary for meeting requirements around safety and integrity, as in order to comply with any federal or state regulations. Mr. Gardner talks about those investments. Any investments incurred to meet customers' requests for service, we have an obligation to serve. That's what I was referring to in this part of my testimony.
Okay. We could go to page 18 of your rebuttal at lines 18 through 20. Here you state the inflationary economic environment is making it harder than ever to control costs when many of the increased costs are simply beyond the company's control. Is that right?
Which lines were those again?
18, page 18, and starting at a line, 17 through 19.
Yes, I see it.
Okay. And as I just asked you earlier, if you were aware of today's news that the Bureau of Labor and Statistics indicated that the inflation rate was coming down. You indicated you had not looked at the financial news today. Is that right?
Correct.
Would you generally agree that the U.S. inflation rate is coming down?
That is my understanding compared to the rates that we saw, the inflation rates that we saw after the pandemic lockdowns. They've come down since then.
Okay. Do you agree that based on the financial news you've read, that the U.S. inflation rate is coming down, and therefore it's widely reported the Federal Reserve will begin lowering interest rates during its September 17 and 18 meeting this next week? Would you generally agree with that?
I do not know what the Federal Reserve is going to do. If I had that information, I certainly wouldn't be sitting here.
Well, would you agree it's widely reported that it's likely that the interest rates are going to be lowered by the Federal Reserve next week?
I would say the market is expecting the Fed to act in that manner. Whether they do or not is yet to be seen.
Okay, that's certainly fair. Let's move on to the second part of your sentence there on page 17 at lines 8 through 10. And here you indicate special circumstances need to exist in order for year-end rate base to be appropriate. Is that right?
Just to clarify, that is what parties have argued, not what I am arguing.
Do you agree special circumstances need to exist, or do you disagree with that?
So that sentence that starts at line 8, parties have argued. So I'm
Yes.
basically summarizing what parties have argued, that regulatory lag is beneficial and that special circumstances need to exist. That's what the parties have argued. That's what that sentence is saying.
Right. And I ask you if do you agree special circumstances need to exist in order for year-end rate base to be appropriate?
The rest of the section of my testimony then goes on to present my arguments that based on the decisions that we've been looking at and talking about, the circumstances of attrition, inflation, growth, attrition, and inflation are the conditions to look at. So if you want to call those special, you can, but that is what my testimony goes on to state, is that the commission has historically looked at those 3 factors, and I present the argument that those factors are present in this case, and try to summarize the information that is presented in this case for those factors, for the existence of those factors.
Okay, if we could turn to Mr. Skluzak's answer testimony, that's hearing exhibit 500 and specifically attachment CWS-27. And if we could scroll to the bottom of page 2. You are the sponsor of Public Services response to CPUC Discovery Request 2-13, correct?
Yes.
Okay. And if we could look at subparagraph C here on page 2. In this discovery response, you admit that regulatory lag is not the only factor that may contribute to under-earning. Is that right?
Yes.
And in subparagraph D of the response to CPUC 2-13, here you acknowledge Piesco has not conducted any analysis to identify and quantify the specific causes of earnings attrition. Is that right?
Yes.
And if we could go back to your rebuttal testimony at page 37, please, lines 4 through 19. Here in your rebuttal testimony, you continue to argue the existence of earning attrition between 2015 to 2022. Is that right?
I'm pointing out that in my direct testimony, I provide a table that compared the actual to authorized ROEs for that time period.
Okay, and you're arguing the existence of that earning attrition between 2015 and 2022 due to regulatory lag justifies the use of year-end rate base. Is that right?
I am pointing out in this section of my testimony that based on one of the three components that the commission decision from 1974 that we've been talking about mentioned attrition, and I am summarizing in this section of my testimony that that evidence was in my direct testimony that showed that Piesco has been under earning over that period.
Okay. And if we could focus here on lines 14 and 15 on page 37, here you dispute the staff and UCA arguments that the level of under earning by Piesco Gas is not high enough to prove attrition. Is that right?
That was staff and UCA's arguments.
And you disagree, and you disagree with that, right?
I disagree with the argument that there is some minimum level of under earning that is required to constitute attrition. I did not see anything in those orders that we have talked about that mention any kind of a threshold or minimum level, merely that the utility was under earning its authorized ROE.
Okay. And in fact, on lines 15 through 17, here you indicate nothing in the commission decisions I quoted requires a specific threshold of under earning to be achieved before attrition is found. Is that right?
Yes.
So the converse of that statement is that Piesco cannot point to a specific threshold of under earnings that does support an attrition finding. Is that also correct?
I think I might have lost you on that question. Can you
Okay,
repeat it?
so I'll repeat it and I'll try to make it a little more concise. So the converse of this statement is that Piesco cannot point to a specific threshold of under earnings that supports an attrition finding. Is that correct?
This sentence says that in the decisions that I reviewed, the one from 1974, I did not see any mention of any kind of a threshold that was necessary in order for attrition to exist.
Okay, I'll move on. Let's go to page 8, please, of your rebuttal testimony. And here at line 17 through 23, your testimony regards the reinsertion of certain investor relation expenses. Is that right?
It's a correction that was made in the rebuttal cost of service. Yes.
Okay. You do not provide the amount of this reinsertion in your rebuttal testimony, is that right?
It appears on attachment APF 136-17 rebuttal cost of service, schedule 1 APF 1202, lines 424 through 429 and 518.
What is the amount of this reinserted amount for investor relations expenses?
One moment, please. If you look on hearing exhibit 136, which is attachment APF 16, page 2, line 1, the revenue requirement impact of this adjustment is $142,769.
Okay, so $142,760?
69.
$69. And you reinserted this amount of $142,000 based on your determination that this amount was for expenses that were not prohibited. Is that correct?
They are expenses that are necessary to incur due to the nature of Xcel Energy being a publicly traded company. And so it's things like listing fees to be listed on the stock exchange and other costs to comply with regulatory requirements. And those are just necessary costs that the company incurs.
And what was the basis for your determination that this $142,000 amount was not prohibited? In other words, did you look at a Colorado statute? Did you look at a commission decision? What did you look at to make that determination?
Those are more compliance costs, if you will, rather than investor relations, meaning, and as I understand investor relations, that's marketing the stock to potential investors, basically going out and arguing or presenting Xcel Energy and arguing why the company is worthy of investment. That is not what those listing fees or compliance costs are. They're costs that are incurred because Xcel Energy is a publicly traded entity.
Okay, thank you for that. Starting on the end of line 19 there on page 8, you there indicate that this amount, which we've determined is $142,000 of expenses, are necessary to comply with applicable legal requirements. Is that right?
That's what it says, yes.
Okay. And just to be clear, is this your assertion or conclusion, or do you have anything to support that in terms of adding this $142,000 back into the cost of service?
Based on my review of the nature of the transactions, they were, like I said, market listing fees, other compliance costs like that.
Mr. Bunker, about 70 minutes in, so.
I just have one more short topic. I'm going to make the 75, I think, easily.
All right.
But let's not get carried away here. I could be wrong.
We have no flexibility after tomorrow, so we got to get this in.
Yes, I understand. Thank you. I appreciate the heads up on the time. Let's talk about your rebuttal testimony on page 12 and at and in particular, here on lines 4 and 5, staff and UCA recommended disallowances of a WAC return on unamortized balances of regulatory assets and liabilities. Do you see that?
I do, yes.
And is it your understanding when we look here on line 17 through 21 there on the bottom of the page, UCA witness Mr. Skluzak specifically, he recommends that the commission deny a return on the unamortized balance of the commission fee, damage prevention, pension expense, and property tax referrals, correct?
Yes.
Is it your understanding that in Public Service's most recently completed 2022 gas rate case, which was proceeding number 24AL-0046G, that in that 2022 case, the commission denied a return on the unamortized balance of the commission fee, damage prevention, pension expense, and property tax deferrals?
That is my recollection of what the commission decided in that case.
Okay, thank you for that. And Mr. Chairman, with that, I am finished with my cross-examination with 3 minutes to spare. Thank you.
We'll add the 3 minutes to the break. Thank you. Commissioner Plant, questions for Mr. Freitas?
I have no questions for Mr. Freitas.
Commissioner Gilman.
Yes, just getting my proper screens up. Good afternoon, Mr. Freitas.
Good afternoon.
So I just have a question for you, kind of a rather general question. I have been working with the executable spreadsheet hearing exhibit 123, attachment RAM5, which you might be familiar as the 15-year rate forecast. And I was getting some results and wanted to run them by you to understand if they're reasonable or not from kind of a revenue requirement cost of service standpoint.
Sure.
So you may or may not be familiar, but within the 15-year rate forecast, the projections are for a fairly pronounced decline in sales to retail customers, but for essentially a projected constant sales to transport customers. And so I was just trying to test and understand what some of the rate projections might look like if we also saw a decline in transport customers within that model. And when I tried that within that model, average rates, so if I decline also sales for transport customers throughout the duration of that model, average rates do appear to rise in base rates and in total, but residential rates do not appear to rise. And I wanted to understand, is that a reasonable outcome, or is it reasonable to assume that if we saw fewer transport sales, there might be some reallocation that then affects other rate class to cover the fixed costs of the system?
So it does make sense that average rates would go up as you reduce sales, you're reducing revenues. And so that average rate going up makes sense. Whether or not a decline in one class would or a decline in sales in one class would affect the rates of other classes, that's a little bit of an empirical question, and it depends on the class allocation that is happening sort of behind the scenes. in this modeling exercise, I'm not sure how they modeled the class allocations happening. If they assumed essentially like perfect allocation where only the costs that are being caused by residential customers are being allocated to them, then it wouldn't, because any changes in the transport customer class would be confined to just that class. So I'm not as familiar with that model to really be able to say whether that's exactly what's going on kind of behind the scenes, and if sort of perfect, what I call perfect allocation is happening or not. But that's how that condition could happen, where you change something from the transport class, but it does not affect other classes, the residential class. So it's not inconceivable. I just don't know the ins and outs of that model enough to be able to definitively give you an answer. I'm sorry.
No, no worries. I've kind of just gotten time to try and test some different assumptions and see some things work. And that's why I wanted to kind of understand the general concept with you. So I guess taking it the other way, all things being equal, if transport sales remain the same and residential sales actually decline 40% by 2038, which is what the model utilizes as a base assumption. Do you anticipate that would lead to a reallocation of those fixed costs among the classes, given a dramatic decrease in a certain set of customers' usage?
I think that's reasonable. I'm sorry. I think that is reasonable to expect, because there's going to be some bucket of costs that will get allocated across all classes in some manner, whether that's on net plant or labor or some allocation method that's internal to the model. And so I can see a reduction in residential, or any other class for that matter, triggering some kind of a reallocation of this bucket of sort of common costs, if you will.
Okay. Okay. That's helpful. I was just trying to gut check what I'm seeing here with what I anticipate could happen if we saw, an actual kind of pronounced decrease.
Right. And in a lot of revenue requirement models, there's what we call internal allocators, which are dynamic and they respond to changes within the model itself. And so that's sort of gets to what I was talking about before, where if this model is modeling those dynamic allocators, it sort of has that perfect allocation built in.
Okay, excellent. Well, that's really my only questions for you, Mr. Freitas. Thanks so much.
Thank you.
Thank you, Commissioner Gilman. I may follow up a little bit on that. But first, I want to follow up on a little bit what Mr. Bunkar was asking you about your rebuttal testimony. Can we pull up hearing exhibit 169 entitled Commission Requested Capital Expenditure Data from 2017 to 2023? Maybe if you can get it in a little tighter. And yeah, there you go. So do you see this, Mr. Freitas?
I do.
And is it fair to say capital spending has consistently increased every year, sometimes more than others, but has never gone down, at least from 2017 to 2023?
I can, yeah, what I take from this table, I agree that capital expenditures have been going up. I will note that it appears that inflation has had quite a material impact on the dollars themselves. Just basically looking at comparing the top table to the bottom one.
Fair enough. Fair enough. And if I represented to you that again, nominal dollars, I'll distinguish between real and nominal for you. The compound annual growth rate between 2017 and 2023, subject to later check, that it was 7%, and 9.3% between 20 and 2023. Would you have any reason to doubt that?
I have no reason to. I'm sure you've done that math properly.
Hopefully. And in 2023, the company spent over $600 million. Do you see that?
I do, yes.
All right. Let's keep this handy, but can we pull up the same exhibit that Commissioner Gilman referred to? It's hearing exhibit 123, attachment RAM5, which is the public version of Mr. Matley's rate impact forecast. Can you dig in a little more? But and I guess I just want to, I think you've already agreed to this with Commissioner Gilman, but in cell F29, it shows sales growth of negative 3.6%. You see that?
Yes.
All right. And I think multiple witnesses sort of supported that was a reasonably likely outcome. Would you disagree with that?
I have no basis to agree or disagree. That's completely outside of my area of expertise, unfortunately.
Fair enough. All right, can we go to the capital tab? And if you can zoom in a little if possible. Do you see modified capital expenditures E14 of 448? Do you see that?
I do.
And do you recall that actual 2023 capital spending from our prior discussion was over 600 million and has risen in every year for 8 years? Do you recall that?
I do, yes.
So given all this, do you believe that actual capital spending in 2024 will be for 448 million?
I don't know that I can speak to that at all, Mr. Chair. I am not involved in the budgeting or the operations side of the business. So I don't have any context to be able to really answer that question in either direction, unfortunately.
Yeah, I appreciate that. It's we just got the capital budget yesterday or this morning. So
yes, I understand, and I'm the last one standing. So
yeah, last guy standing. And I also heard Mr. Piquet and Mr. Matley testify that there is no basis in existing law or practice to assume that capacity expansion and new business go to zero as assumed here. Again, with a full recognition that you're not the witness to opine on that, would you have any basis to assert that characterization is wrong?
I have no basis to disagree with either what Mr. Matley or Mr. Piquet have indicated. I think they know better than I do.
Okay. You can take this down. Do you have any long-term rate impact concerns about continuing to grow capital spending in a declining sales environment?
That's a broad question. I'm not quite sure
All right, fair enough. Any advice about how we can help the company manage it down before I give you one suggestion?
So I think that many of the witnesses have talked about the importance of maintaining the safety of the system, and that is likely to require investment. I would maybe caution that that is necessary investment, and managing down investment, we may want to focus on areas that are sort of less critical to public safety, if you will.
Like the $5 million we spent subsidizing 90 homes at $80,000 a home. Let me just, all right, let me get to it. In your rebuttal testimony, you talk about end of year versus 13-month average rate base determinations with a historical test year. Given the differences between these two approaches, has this commission ever picked a date in the middle? For example, in this case, could we set rate base as of 9/30/2023? I mean, it wouldn't satisfy anybody. It's sort of a cut the baby in half approach. But it's exactly in the middle of what you're asking for and what staff and UCA is asking for. So, and it's really what the record says in some ways. Any awareness of whether that's been done here or elsewhere? And I'll start with that and then
Sure.
ask for your advice about if we did go that way, if you had any concern. So any experience with that?
A little bit in the 2019 electric rate case. The test year that was ultimately settled on was it was a little bit of a hybrid test year. It was really complex. It was for existing capital, it used year-end rate base, but measured at the beginning of the test year. And then for capital additions over the 12 months of September 2018 through August of 2019, it used a 13-month average for those capital additions. That test year actually turned out to be really complex and really complicated and difficult to really understand and see what was going on. And that was, if I remember correctly, that was a test year that was kind of picked towards the end of the case, either during hearings or through ARRR. And it was, again, sort of one of these, can we figure out a compromise in between? And it turned out to be really kind of suboptimal because it causes problems when you're looking forward and figuring out, well, what exactly changed from last case to this case, as well as just the difficulty of trying to calculate the revenue requirement itself. And you're trying to take two different rate-based methodologies and averaging conventions and sort of squash them into one period, and trying to separate out the investment and apply one averaging method to one bucket of dollars versus another. That was, so my recommendation and caution would be definitely avoid some kind of method like that where you're trying to combine two different methodologies in the same test year. That did not work very well at all. As far as just picking a different test year.
Not a different test year. So I guess I hear that. But assume we keep the same test year, but instead of looking at rate base in June 30th or end of year, we just look at September 30th, 2023. And so it's just really simple. It's 9 months. Would you have any advice or concerns if we did something simple and straightforward like that, with the hope that somebody 50 years from now will be talking about this decision?
So my cautions would be that in order, if we just pick a month inside of the test year, I don't know that we have the information to be able. Let me step back for a second. If we picked, let's say, June or September, whatever month is appropriate, we would want to line up, depreciation expense and some of the other components of the revenue requirement to line up with that period in time that we're choosing for rate base. Revenues, for example, O&M, and I don't know that we have sufficient information in the record to be able to recalculate all of those income statement accounts for basically 12 months ended September or whatever point in time we want to pick. That's one concern I would have is in order to really maintain that matching of rate base to the expenses, we would need to move expenses around in time a little bit as well and recalculate those. And I don't know that we have that information to be able to do that. That would be my concern.
So because of UCA's and staff's discovery requests and whatnot, there's a full record on a June 30th rate base. And because of your recommendations, there's a full record on a end of year rate base. But because this is coming up late in the hearing, there may not be a full record, and it could cause record and due process problems that may not be solved with a technical conference. Is that what I'm hearing?
That's what I would be concerned about, right?
All right. That's all I have. Ms. Brahma, redirect.
Chair Blank, I wonder, would it be okay with the commission if we took a short break right now? I think it might be helpful to explore a little bit of the issues that were just raised and see if just give us a moment to think about it, and if there's a way to do something that may be useful before we
All right.
last witness leave the stand.
Yeah, fair enough. Is 10 minutes enough or you need more?
Could we have 15, please? Would that be all right?
All right, we'll come back at 2:50.
Thank you.
Thanks. So, Ms. Brahma, if you would need a little more time to confer with your client after talking to counsel, I think we'd be willing to go start with the staff witnesses and come back. I think we'd like to see we get this one right then quick, but if you're ready, go ahead.
I think we're ready, Chair Blank, but we too would like to get, to have the right answers. So I have some questions for Mr. Freitas on that topic. And if it presents more questions from the commission, I think what we would ask then is to let's find that out. And then we can come back and see if there are any further questions that we need to address. If what
Right.
we talk about here doesn't solve what the commission's looking for. So maybe let's just start with that last topic, Mr. Freitas, and the chair's questions about how might the commission split the difference if it didn't feel comfortable with either a 13-month average or year-end rate base? Should you maybe speak to that a little bit further?
Sure. So we have in the record in my testimony that the value between average rate base and year-end rate base is approximately $18 million. So from a revenue requirement perspective, one option would be the commission could find an appropriate number in that range of $18 million between year end and average rate base and order a rate making adjustment to, for example, bring the revenue requirement down by some amount from the company's rebuttal cost of service, for example. So start with what I have in my attachment in rebuttal for the rebuttal cost of service, and then order some adjustment that the commission feels appropriate to reflect the balance between an average and year-end rate base. That would be one way to do it, just from a revenue requirement perspective.
Are you taking, or on behalf of the company, are you taking a position on whether that is preferable or the policy bases for doing that as opposed to the company's preferred year-end rate base?
That is just from a purely revenue requirement calculation perspective, how it could be effectuated. I don't know that I'm the proper witness to be able to speak to what the company's policy preferences are.
And just from a revenue requirement modeling perspective, if you could speak to what you're suggesting, how that would reflect what's in the test year as for purposes of plant and service and O&M and the other components of the cost of service.
Sure. I would maybe recommend that the commission adopt the 2023 test year that includes all of the capital and O&M and other costs that are in that test year, and then make this as a commission ordered adjustment to the revenue requirement, rather than trying to recalculate everything within the revenue requirement itself. I think this approach would be much cleaner, and it wouldn't raise any, I don't think, any issues in terms of, well, what is or isn't in the test year in terms of capital, which, as I mentioned in that 2019 electric case, with that hybrid test year and the two different rate-based convention methods, a lot of those questions were raised. So I think coming from the perspective of picking this test year that was presented in rebuttal and then adjusting through a rate-making adjustment is much cleaner.
Is what you're suggesting in the nature of a prudence type investment, or is it something different than that?
It's purely a rate-making adjustment, and that's it. So I would include in the calculation of the revenue requirement some adjustment to adjust to the revenue requirement by down by an amount that the commission feels is appropriate.
And if the commission were to take this path, starting with the 2023 test year, through the end of 2023 cost of service model presented in your rebuttal, then where would the company start in terms of looking at capital for its next rate case, regardless of when that may happen?
So as far as the next case is concerned, that review would be for the period of January 1st, 2024 forward to whatever the test year for the next case happens to be. So what we would be finding in this case is that the capital has been reviewed through the calendar year 2023, which is the test year in this case.
This is rather unusual, but I'm going to pause there for a moment because I think we are trying to work with the dialogue with the commission to see if that answers the questions before I go to just a few other items of redirect that'll be fairly brief.
I think that's where it's at. So I just keep going.
Okay, thank you. So Mr. Freitas, I'd like to, if we could just pull up Mr. Skluzak's answer testimony, Exhibit 500 at page 41. So I'm a little bit concerned, Mr. Freitas, that this table is creating unnecessary confusion here. And first of all, can you identify which of these were provided because staff and or the UCA asked for additional modeling and discovery?
Let's see, the green line second from the top was provided as a result of discovery. The fourth line down, the green one, was provided as a result of discovery, and the bottom two rows were also the result of a question we received through discovery.
Okay. And what were the models that the company proposed or provided, not proposed, let's just say provided with its direct case?
The top row and the third row down in red, the proposed Piesco. Those were the two that were included in my direct testimony.
And just to clarify, one of those is to provide 12 months of complete actual data, and then with known and measurables, and the other was with the forecasted 3 months. Is that right?
That's correct.
Okay. And then in rebuttal, do any of these represent the company's actual rebuttal model?
They do not.
Okay. And where would we find that?
That would be in my rebuttal testimony, attachment APF 17.
Okay. So with the staff and UCA's discovery, did the company go ahead and prepare all these models, whether or not it agreed with them?
Yes, we responded to the discovery questions that the parties asked.
Okay. We can take this exhibit down. Thank you. Mr. Counsel for UCA asked you some questions about what in current inflation versus inflation in February of 2021. Do you recall that discussion?
I do.
So do you have any sense of what was happening with inflation in February of 2021 and since that time?
Just start out by saying, I'm not an economist or an economic forecaster, but I do recall just from having to buy gas and groceries and things like that, that inflation was really high during that time period shortly after the pandemic. I remember the financial headlines talking about inflation being at historic levels, 40-year type headlines saying that inflation hasn't been seen these levels of inflation haven't been seen in quite some time. I recall that happening in that time frame.
If we have inflation at a rate comparable to February of 2021 now, does that equate to decreasing costs? Or how does that, how does an inflation rate compare to, or relate to the cost the company has been incurring and continues to incur?
So inflation is generally defined as the rate at which prices increase. And so declines in inflation is not declines in prices. That is a lowering of, let me step it. There's a couple double negatives in here. Lower inflation means that prices are still increasing, but they are just not as increasing as fast as they were at some previous period in time. So yeah, prices are not decreasing with lower inflation. Those are different concepts.
And if inflation rates are not rising as fast as one might expect, do you have any sense of how that tends to relate to interest rates?
Again, I think Mr. Johnson's probably a much better witness to be able to address the impact of inflation on interest rates, but my understanding is that the two are linked, and interest rates tend to respond to changes in inflation.
Perhaps most importantly, since we'll get back to your area a little bit more directly, Mr. Freitas, but is the company proposing to put plant in service as of today in relation to today's inflation rate?
I mean, you can maybe ask that question a little differently. I don't think I quite followed it.
Sure. Is the plant in service included in the company's requested rate increase, reflecting plant in service new through today, or is it from a different time frame?
No, the plant and service and other plant costs that are in the cost of service reflect costs through the end of 2023.
Okay. If the commission were to adopt the company's request for year-end rate base, and the company's test year and other proposals in this proceeding, to what extent will regulatory lag still be part of the rates the company would be implementing as a result of this case?
There would still be, even with year-end rate base as it's proposed in rebuttal, there still would be a fair amount of regulatory lag that's affecting the company. And actually, in my rebuttal testimony on, let's see, I can find it real quick. I have a graph that kind of demonstrates this.
I think I found it, Mr. Freitas. Were you looking at page 25?
Yes, page 25, figure APF-R-2. So that will. So this figure is showing rate base from this case. So that vertical line is December 2023, the end of the test year. The gray line represents what rate base has done since December through June of 2024, which was the last month of actual data that I had available. And then the orange line is if year-end rate base was adopted, that's the level of rate base that would be incorporated into rates. And then if 13-month average rate base was adopted, that blue line below it represents what would be incorporated into rates. And also one thing to keep in mind is if you compare this graph to the one just above it in APF R1, You'll notice the top graph has two vertical lines. The first vertical line to the left represents the end of the test year, and then the second line represents the basically the implementation of rates. Because we haven't reached the rate implementation date yet, there's not a second vertical line on the bottom graph, but in the time between the end of the test year, in this case, to when we put rates into effect later this year, rate base will have continued to increase. And so that difference between the gray line and the orange and blue lines is going to continue to get bigger.
And we can take this down. Thank you. Mr. Bunker asked you some questions about whether the company had done a quantitative study to specifically identify all the components of what might be leading to earnings attrition. Do you remember that discussion?
I do.
How do you know that regulatory lag is the largest contributor to earnings attrition for public service?
Well, I think the graph that we just looked at, those two graphs kind of illustrate it perfectly. Regardless of whether year-end or average rate base is used, there's still a pretty sizable difference between the actual rate base line and the lines that represent the conventions that are adopted for a revenue requirement calculation. Because you can think of those lines as the gray line represents actual costs incurred, and then those horizontal lines, whether they're average or year-end, represent the costs that are embedded in rates. And so that difference represents regulatory lag.
Could we pull up hearing exhibit 169 quickly, please? And then I will wrap up. Mr. Freitas, you had a brief conversation with the chair about the increases in CapEx from between 2020 and 2023. I think we've talked a little bit about inflation. Could you speak to, just at a high level, how inflation and perhaps supply chain have affected the company very holistically, because I know you're not the business area witness, over the last couple of years?
Sure. Well, as we just talked about, back in early 2021, kind of after the lockdowns, we were seeing historically high inflation rates, and that has been impacting these numbers in the 2021, 2022 timeframe. And then, in addition, due to the lockdowns, I know that in speaking to colleagues, there was quite a bit of difficulty in obtaining pipe and other materials that are needed for these projects. And so, during the pandemic, there was a bit of a slowdown in construction due to supply chain issues. And so, as we got caught up, some of the capital expenditures that maybe would have happened earlier in this period kind of got pushed to later in 21, 22, and 23, just as due to supply chain constraints. And as those sort of worked themselves out, we were able to do the work that, had there not been those things happening, we may have been able to do earlier in time.
And then lastly, Mr. Freitas, just quickly, there was a comparison between the 600 million nominal CapEx here in 2023 in this chart, and 400 and some million dollars in one of the schedules that Mr. Matley provided. Do you recall that discussion?
I do.
Are there some additional lines of costs that are included in this particular chart that were not part of that particular schedule with the 400 and some million that Mr. Matley had provided?
I know that this chart includes technology and shared services, and I believe the CapEx in Mr. Matley's in his model might have been just the gas only system. So I think there's that disconnect there that is accounting for some of the difference.
Thank you. That's all I have.
Thank you, Ms. Rama. Mr. Freitas, you may be excused.
Thank you.
Mr. Bunker.
Yes, thank you, Mr. Chairman. If we're finished with public services witnesses, but before they rest their case, just a housekeeping matter, and that is I see that one of the UCA exhibits that was admitted during my cross-examination of Mr. Johnson, I see that 2 pages were left out of the document, and it perhaps as easy as to pull up the document out of the box.com.
Can you let's not do this in live hearing. Can you work with counsel and see if you can get that fixed offline with the legal assistance? And if you have a problem, even with public service company resting their case, we'll get the record fixed. Would that be all right?
Yes, that'd be fine. I was just going to replace the document while we were still in public services case, but that's fine.
Yeah, I mean, as long as the records, Ms. Harper, as long as the record's open, I think we can do it today or tomorrow, right?
Yes, and if he has an updated version to move for admission right now, we could do that, or else if it's more complicated, then we can correspond by email.
And to Ms. Harper's comment, I do have a updated copy in box.com.
All right, you want to pull it up?
Sure, it's hearing exhibit 509. And this is a discovery request, UCA 28-8. And there were a number of questions to Mr. Johnson about this. And what I found is there's a supplemental response, and page 2 and page 6 of this document were left out of what I admitted or had admitted. So it would be this language here on page 2, and then this page on page 6 that dealt with the various 7 scenarios that were in Mr. Johnson's testimony. And this last page, as it turned out, there were 2 Excel spreadsheets plus a PDF plus the response, and I think we got 3 out of the 4 and missed the last page of the second page of the response. So all I'd like to do is just supplement this document in so that the record's complete.
Any objection, Ms. Brommer, or do you need to take a look?
No objection.
So admitted. Thank you, Mr. Bunker.
Yes, thank you. And thank you for letting me just deal with this real quickly as we were still on the record. I appreciate it.
Yep. Staff. Doctor.
Thank you.
Yeah, go ahead.
Thank you, Chair. Staff calls Dr. Dipesh Depew to the stand.
Dr. Depew, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Is anyone with you or communicating with you in any way?
No.
If that changes, you'll let us know.
Yes.
Mr. Cox.
Thank you. Good afternoon, Dr. Depew. Could you please state and spell your name for the record?
It's Dipesh Dipu. Dipesh Depew.
And by whom are you employed, and what is your title?
By Colorado Public Utilities Commission, and my title is Chief Rate Financial Analyst.
And in this proceeding, did you cause to be filed answer testimony, including attachments, which has been marked as hearing exhibit 402?
Yes.
And if I asked you the questions contained in your answer testimony, would your answers be the same today?
Yes.
All right. Thank you. Dr. Depew is available for cross and commissioners' questions.
Public service, I have 60 minutes. Ms. Brahma, but you're on mute.
There's me again. Good afternoon, Doctor. Was it Deepu? Is that how it's pronounced?
Yes.
Thank you. My name is Liz Brahma. I'm an attorney with the Taft Law Firm representing Public Service Company of Colorado in this proceeding. It's nice to meet you today.
Nice to meet you too.
I'm going to ask you to speak just a little bit louder because it's a little bit quiet.
Okay.
Okay, thank you. I'd like to start with your answer testimony. We don't have to pull it up quite yet, but just with respect to your discussion on the cost of debt, please. Now, you discussed one number for cost of long-term debt and another for cost of short-term debt in your answer testimony. Are you aware that commission staff provided corrections to the answer testimony of staff witnesses, Aaron O'Neill and Luis Rivera Lugo, with respect to the calculation of the costs of long-term and short-term debt?
Yes, I do.
And you're aware, for example, that Ms. O'Neill identified in her Rev 1 answer testimony that what she called the pre-tax long-term cost of debt would be 3.25% rather than 2.44%. Is that correct?
3.25% is pre-tax and 2.44 is post-tax.
Okay. Are you aware, though, or do you understand that the tax shield that you discussed in your testimony is already included in the revenue requirement through the cost of service model itself?
Yes, I was appointed to that subsequent to our filing of answer testimonies. And while examining the direct testimony, I couldn't figure out the interest computation in the revenue requirement, primarily because it was hard-coded. And I do understand that the post-tax cost of debt, as it should be in computation of weighted average cost of capital, is what I have proposed, and it's actually reflected in the revenue requirement, but not stated as such in Ann Bulkley's testimony.
Okay, and just to be clear, there are actually two issues that have been raised with your statement of the cost of debt. There is the tax shield, right, which is what we're talking about here, is already accounted for in the cost of, or in the cost of service study, correct? So would you agree that the cost of long-term debt and short-term debt should at a minimum be updated to reflect what Ms. O'Neill has in her testimony and in Mr. Rivera Lugo's cost of service model?
Not really, because I think we are talking about the nomenclature. And if you look at any textbook on financial management, even the textbook suggested by CFA Institute for their certification, even the way the investment community understands weighted average cost of capital, they always consider post-tax cost of debt and then arrive at the weighted cost of capital on post-tax cost of equity and post-tax cost of debt. So what the company has done is to use pre-tax cost of debt and mix it with post-tax cost of equity, which is not the normal convention used anywhere else.
Okay, are you familiar with how rate making is done for? You are?
Yes.
And are you familiar with the fact that this is how the company has shown and provided its cost of debt for many years at this commission and other commissions in which Xcel Energy operates?
It has, but it has significant signaling impact on ratepayers, on investors, and also other commissions.
Okay, so let's get, oh, I apologize. I didn't mean to interrupt.
Yeah, so essentially what I'm trying to say is that when the company asks for a weighted average cost of capital of 7.5%, it doesn't reflect the true approved weighted average cost of capital. It is just the pre-tax and pre-tax cost of debt and post-tax cost of equity, which is perhaps, I mean, in financial community, this is never done.
So, all right, so that's the financial community, but I'm trying to get to ultimately, if we were to take your 2.44% cost of long-term debt and then reduce it to account for the tax shield, when that tax shield is already accounted for in the revenue requirement,
Mhm.
Doing that would double count the tax shield, correct?
Well, the idea that I'm proposing here is that there would be no change in revenue requirement, but the semantics of how weighted average cost of capital is represented to ratepayers, investors, and other stakeholders needs to be corrected.
I think that's where we're trying to get to, Dr. Deepu, that it's a semantics issue. We don't further subtract the tax shield from a 2.44% cost of long-term debt, right?
Yes,
Okay, thank you. And the same thing would be true with respect to short-term debt.
yes.
Okay. Now, the second piece, now having gotten that clear with respect to the cost of long-term debt is what that you call the 2.44 or the 3.25 with the tax shield accounted for is the company's quote effective interest rate. Is that right?
Yes.
Okay. Now, this is based on the company's total on and off balance sheet debt. Is that correct, Dr. Deepu?
That's based on the company's response to my discovery question.
Okay. And that discovery question asked for, did not ask for the observable line item by line item interest rate on the company's debt, right?
Typically, when we say effective, it should reflect all of those outstanding debts and their respective interest rates, and then we compute effective interest rate.
Okay. And isn't it correct that that effective interest rate, as you asked for it, as the company explained in testimony, includes both on and off balance sheet debt?
Wasn't that in the rebuttal testimony?
Correct.
Yes, but
Okay.
not before I wrote my testimony.
Okay. And isn't it correct too that, well, let me just ask this question. Did you add, or did the staff in calculating its revenue requirement add those same off-balance sheet obligations to its rate base calculation? If you know?
No, I'm not sure.
Okay. Now, did you, I'm going to ask if we could please pull up hearing exhibit 154, please, from the company's box. Are you aware, Dr. Deepu, that the staff asked that the company provide all discovery responses provided to any party, in this case, to staff?
Mhm.
Was that a yes?
Yes,
Okay, thank you. We have a court reporter, so we need yeses and nos to make sure it's effective in the
Sure.
record. Did you happen to review this response to UCA request 1-8 to the company?
This seems to have skipped my attention.
Okay. And just noting it for the record, this is received February 8th of 2023, correct?
Yes,
And your testimony, answer testimony was filed in July of 2023, is that right?
yes, yes.
And if we go to the attachment to this, the next page. This document shows the actual observable debt offerings and interest rates for each of the company's offerings as of December 31, 2023, correct?
Yeah, it says so.
Okay. And that number on the lower right-hand side, the 4.05%, equates to the amount of long-term debt reflected in Mr. Johnson's direct testimony. Is that right?
Well, I can't authenticate it, but yeah, it says so.
Okay. And then if we could, well, I'll move for admission of this document, please.
Any objection, Mr. Cox?
No objection, but just one clarification. If we could scroll up to the first page. I think, or if we could maybe scroll down a little bit. Was the representation that this was the reply or the response was in February?
That's
It's still on the first page. I think that date there says March 11th.
Thank you for the clarification. You're right. I was looking at the date received by the company, not the date provided by.
Yeah, that's what I thought the confusion was. But yeah, beyond that, no objection.
Okay. Thank you. Are we okay to have it admitted?
Yes, sorry, so admitted.
Thank you. If we could take this down, please. And if, we could also, pull up, hearing exhibit 126, attachment PAJ 24. This would be the rebuttal testimony of, witness Johnson. And while we're doing that, Dr. Deepu, are you aware that the company provided a discovery response in April of this year with an update to its long-term debt as a result of an issuance in April of this year?
Yes.
Okay, so if we could take a look at hearing exhibit 126, attachment PAJ 24. And again, this shows, does it not, Dr. Deepu, all of the debt issuances from the company, including an offerings in April of 2024. Do you see that in the date of offering column?
Yes, I see that.
And do you see on the lower right-hand corner of this attachment, the 4.27% cost of long-term debt reflected in Mr. Johnson's rebuttal testimony?
Yes.
Okay, thank you. That's all I have on this exhibit. So at this point, I'd like to turn to your answer testimony, Dr. Deepu. This would be hearing exhibit 402 at page 57. If we could scroll down a little bit, please. Let me make sure I have my pages right. Oh, I apologize. I scrolled too far. It should be actually at the top of the page, still same page. So just to clarify for just a moment, on line 4, is it correct, Dr. Deepu, that staff concluded that an ROE of 7.40% based on cap M is appropriate?
Yes.
So that is the result of your cap M model. Is that
Yes,
correct?
it is. Yes.
Okay. So if we could turn to page 28 of your answer testimony. And I'd like to look at table DD8 on this page. So just to kind of level set what the CAPM represents in your analysis, the 7.40% in this table is the average of 4 different ROE calculations over 5 through 20-year periods. Is that right?
Yes.
Okay. So just keep that in mind for a moment. And if we could now turn to page 31 of your answer testimony. And there you say staff uses the DCF method to provide a second methodology for calculating ROE. Is that correct?
Yes.
Now, there's not just one DCF method. Is that right, Dr. Deepu?
Yeah, there are 2 that I have used.
Okay. So in the second question and answer on this page, if we scroll down a little bit, well, you refer to DCF methods in the plural. Is that correct?
Yes.
And that's because there can be, in addition to a constant growth DCF, a multi-stage DCF, there could be a 2-growth DCF. Is that right?
Yes.
Now, on page 34 of your answer testimony, at lines 13 through 15, here you express that there are dangers in analyzing any single firm stock with the constant growth DCF formula. Is that right?
Yes.
So is it correct to say that for that reason, you do not consider the constant growth DCF to be as reliable as the multi-stage DCF model?
Yes.
Okay, and as we already discussed, I think there is a 2-growth option, but you don't use 2-growth DCF, you use a 3-stage multi-stage DCF, right?
Yes.
Okay. Is there any reason why you jump straight from a constant growth DCF to a multi-stage DCF?
Well, the growth rates available for the next 4 or 5 years, sometimes for a decade, is available from some of the sources that do estimation of growth rates. But for the intervening period, which is between, say, 5 to 10 years or 10 to 15 years, there's usually no source available. So the assumption typically is that the growth rate assumed in the first phase tapers off to a long-term growth rate, which is expected in the third phase. So that's why, because of lack of data, reliable data, I chose this.
Are you aware that there are multiple commissions that rely almost entirely on two growth DCF models?
No, I'm not aware of.
Okay. If we could turn to page 44 of the same document, please. Now, in conducting your modeling, and here we're looking at the multi-stage, but at lines 13 of this page, you say here that when you are conducting your models, first of all, again, the multi-stage is more reliable in your view, correct?
Yes.
And then you also say that quote, the gas utility comparable companies are better suited for estimations in comparison to the diversified utility peer group because the company's business profile is that of a gas utility and not a diversified utility. Is that right?
Yes.
Okay. So let's take a look at your multi-stage model if we could, and we can move to page 57. So just briefly here, and thank you. I don't know if we have Ms. Federico or Ms. Kunkel, but thank you for jumping around with me a bit. Your multi-stage model result is 8.02%. Is that right?
Yes.
Okay. So I'm going to ask you to please jump back to page 43. And if we look at the table DD13, to get to your multi-stage DCF outcome, first of all, this is based on 5 gas utilities ROEs as calculated using your multi-stage DCF under 3 scenarios, right?
Yes.
And then you average the results of each of those 3 scenarios to come up with 3 individual averages. Is that right?
Yes.
And so you have 3 averages, each of which is the average of 5 other calculations. Did I say that
Yes.
right?
Yes.
And then you average those 3 averages, each of 5 other averages to come up with your 8.02%. Is that right?
Yes.
Okay. And then to get to your final result in this, at page, going back to page 57, one more time. In order to come up with your range, you have the 7.40 CAPM to your 8.02 multi-stage DCF. Those form the bounds of your range. Is that right?
Yes.
And did you factor in your analysis, speaking to these models at all, actual authorized ROEs for gas utilities in the United States or for any of the entities in your proxy group or otherwise?
Well, the straight answer is no, but there are reasons for that, and I can explain. One of the reasons why I thought similarities of returns are doubtful, primarily on account of the way those returns are computed. So, for example, from companies' own mechanism of how they represent cost of capital by using post-tax cost of equity and pre-tax cost of debt, whereas the other utilities in other jurisdictions perhaps use post-tax cost of debt and post-tax cost of equity. So in some sense, there is a lack of comparability on account of the ways those are computed. And of course, there are other things which could be different, like the PIMs, the clean heat plans, and DSM. Some of them have historic test years, some of them have future test years. So to me, it appeared that those merely comparing the authorized returns from various jurisdictions is not a reliable way to establish ROE or other returns for this case.
Okay, from a modeling perspective, right? Because you do talk about investor expectations later in your testimony. Is that right?
Yes, I do, but not from modeling perspective, yes.
Okay, so just to clarify, your actual recommended range for ROEs in this case is 8.75 to 9.25%, or a point outcome of 9.0%. Is that right?
Yes.
And we'll get to the reasons why in a minute, but isn't it also correct that that range has no overlap with your modeling results set forth here on page 57, lines 6 through 8 of your testimony?
Yes, and as you can see on this page itself, I've explained the rationale behind choosing that range. Yes.
We will get there. And isn't it also true that to the extent your any of those results, well, I'll skip that question. Let's go ahead and turn to pages 57 to 58 here at the bottom. So we'll start with line 14. Here you discuss why that the staff's ROE conclusions will not impact the company negatively for two reasons. So I'd like to just talk through those a little bit. But so the first one here is that investors in the marketplace that look for investments in gas utility industry will find that authorized rates of return for the company are comparable to its peers. Is that right?
Yes.
And then the second one is that while the company may contend that lower authorized returns provide a negative signal to investors, investors weigh earned ROEs more than authorized ROEs, and the company's historical financial performance indicates that the new authorized ROE recommended by staff will align with the company's earned ROEs. Do you see that?
Yes.
Okay. So when we look at this section of your testimony, pages 57 to 58, and then if we also skip ahead just briefly to pages 62 to 63, where you have your reconciliation of findings, here you talk through some of these considerations, but you don't provide a numeric reconciliation between your models and your recommended range. Correct, Dr. Deepu?
Yes, these are more subjective understanding of how the company itself and perhaps the investor community may react to the proposals that I set in the testimony.
Okay. Now you do, the one part I could find where there was maybe some numeric reconciliation was with respect to flotation costs, which account for approximately 0.90%. Is that right?
That's suggested by company witness Bulkley.
Okay, and you reject the concept of including flotation costs in an ROE determination, is that right?
Yes.
But at the end of the day, flotation costs are not mathematically added or subtracted to either your DCF or CAPM analyses, right?
Yes.
So they don't really make up any portion of the difference between your analytical outcomes or ultimately your 9.0% ROE recommendation. Is that right?
Yes, they do not.
Okay. So going back to page 57, I'd like to just walk briefly through the two reasons you give why things don't, or why your modeled ROEs you don't think would negatively affect the company. So taking them each in turn. When you say that investors in the marketplace that look for investments in gas utility industry will find that authorized rates of return for the company are comparable to peers because the returns for the company are computed based on the equity betas of the peers, where is your comparison to how your 9.0% recommendation compares to other gas utilities ROEs?
I'm talking still about the model, the outcomes of the model here.
Okay, so where in your testimony do you explain and show how a 7.40 to 8.02 range would compare to other utilities in the United States authorized ROEs?
Well, I think I meant to say that the outcome of the modeling is based on comparable betas of the companies which are in the peer group. I didn't mean to say that the authorized rates of returns for other utilities are comparable to these models.
Okay. Have you run any comparisons, and I'll just say, because I didn't see any, of how an ROE recommendation of 7.4 to 8.02 would affect the company's credit metrics or credit ratings? I didn't see any numeric modeling of that.
I didn't use the outcomes of the models, but my final recommendation of 9% was tested on that model, which company witness Johnson provided.
Okay. And you heard Mr. Johnson say that the model that he provided assumed only staff's changes to the cost of capital and did not take into account the other negative impacts of other recommendations the staff may have offered in this case. Did you hear that?
I saw the models that he talked about, and I think what he used was 8.89, which was lower than the recommendation that I made.
Okay.
And yeah, and I think he still continued to talk about how in gas industry, in gas business, there would be only incremental reduction in the credit metrics that he showed in his rebuttal testimony.
Okay, so while on the topic of that 8.89, could we just take a moment here? We're going to come back to Dr. Deepu's answer testimony, but could we please pull up hearing exhibit 401, Rev 1? That would be staff witness O'Neill's answer testimony. Sorry, it's taking a second to load. No problem. Page 16, please. So, Dr. Deepu, do you see Ms. O'Neill's table ETO 3 and hearing exhibit 401 before you on the screen?
Yes.
Have you reviewed Ms. O'Neill's corrected answer testimony?
Yes, I have.
And do you see on the line labeled composite ROE that Ms. O'Neill showed a min ROE growth rate of 8.89%?
Yes.
And that assumes a cost of debt of no, let me rephrase that. That assumes an ROE high end applied to certain categories of company investments of 7.71%.
Yes.
And would you agree, Dr. Deepu, that in looking at a calculation of credit metrics as a result of the staff's proposed cost of capital, regardless of whether it was calculated on a composite average basis or whether you applied one ROE to some components and one ROE to other components, at the end of the day, that those two different ROEs will be factored into what cash flow the company ultimately brings in?
I'm not sure what exactly you mean.
Maybe if I rephrase the question, it will help. Would you agree that whatever ROE, singular or plural, the commission were to adopt would ultimately factor into the company's calculation or to credit rating agencies' calculation of the company's cash flows and therefore its credit metrics?
Objection calls for speculation.
Ms. Brahma?
I'm asking for his understanding. I'm not asking for him to speculate about specifically what they would do, but in the context of the models in this case with respect to credit metrics.
Well, I think the question was whether the credit rating agencies or the company would how they would take this into account. Certainly he can't speak for them.
Would you rephrase, Ms. Brahma?
Sure, I'd be happy to. Dr. Deepu, at the end of the day, when we're running a model like the one Mr. Johnson provided in this case, if you have one or more ROEs, those both need to be accounted for to properly represent the company's cash flow metrics and therefore its overall credit metrics in those models, correct?
I think that's what he did.
And I'm asking, isn't that what you would need to do to properly reflect what ROEs were actually awarded in this case?
Yeah, I haven't done the computation of cash flows and computation of composite rates of return, so I'm not sure if that's something that I can attest to.
Okay, maybe let me just try it one other way and then we'll move on. But Dr. Deepu, wouldn't you agree that if the commission adopts, let's say, a 7.71% ROE for some portion of assets and a 9.0% ROE for other portions of assets, in order to properly reflect cash flows, you need to account for both outcomes that the commission were to implement. Is that right?
Yes.
Okay, thank you. And just one other question about this particular chart. The long-term debt growth column, if you could take a look at that, please. You see the composite ROE that Ms. O'Neill calculated or had calculated at 8.50%.
Yes, I see that.
That assumes an ROE growth rate of long-term debt of 3.25%, correct?
Yes.
So would you agree that if the 3.25% did not properly reflect the cost of long-term debt of the company, at a minimum, the composite ROE would need to be increased to reflect the actual cost of long-term debt?
If that's the hypothetical case we're talking about, yes.
Okay, thank you. One other just quick question here with respect to we're going to go back to your answer testimony at pages 57 to 58. So we're back to hearing exhibit 402. With this note that investors in the marketplace look at authorized returns for the company are comparable due to betas. At a minimum, we would have to compare gas utilities. Is that correct?
I have compared the gas utilities betas.
Okay. And have you looked at the average authorized ROE for natural gas utilities in the United States for 2024 year to date, for example?
Well, like I mentioned earlier, because of differences in the way those are computed, the numbers, the authorized rates of returns are not really comparable to my understanding.
So is it your position that the commission should not consider at all whether the company is awarded an ROE that is reasonably comparable to what it would need to obtain in the marketplace, or what it's not reasonably comparable to whether it's what investors would require of the utility?
Well, if I understand how fair and reasonable returns are computed, it's based on companies which are similar in business profile, similar in their businesses, so to say. They should have similar kind of returns. And I think that's what I purported to do in this testimony.
Okay. And I guess at the end of the day, we can look at your testimony as to whether or not you took into account whether your 9.0 or your model results, how they compared to other natural gas utility ROEs, right? It's all in the paper. Is that fair?
Yes, it's a proposal that I have recommended, and of course it can be considered by anyone else.
Okay, let's turn to your second reason here, please, which is letter B, starting on line 18. And I'd like to particularly focus on the second sentence of Part B that says the company's historical financial performance indicates the new authorized ROE as recommended by staff will align with the company's earned ROEs. Do you see that?
Yes,
So given that belief, it follows that reducing the company's ROE in this case will also reduce the company's earnings or its earned ROE as a result. Is that fair?
no, that's not what this says. What it says is that historically, the company has earned rates of returns, or ROE to be more precise, closer to 8%, which is something that the range that I have computed from the models suggest.
Okay, and I guess what I'm asking Dr. Deepu is when the company has whatever ROE the company has earned in 23, 22 and earlier, that was under an authorized ROE that's higher than what you're recommending now. Is that right?
Yes,
Okay. So you also you're also indicating that the new authorized ROE as recommended by staff will align with the company's earned ROEs. So I'm going to ask if we could please pull up hearing exhibit 400 Rev 1, and I can give you a chance to pull it up. This is Ms. Geber-Zabir's answer testimony. And if we could go to page 58. Thank you. Dr. Deepu, do you see on table NTG8 on page 58 that in 2023, public service earned an ROE of 5.01% or thereabouts against a range of 9.2 to 9.5%?
yes, I see that.
Do you consider that to be aligned with an alignment between the earned ROE and the authorized ROE?
Well, if you see the numbers for 2022, 2021, and 2022, those are the numbers that align very well with my computed models.
Okay, so by aligned, you mean anywhere from, oh goodness, 120 basis points to something less than 100 basis points below the authorized ROE? That's alignment in your view?
No, I'm not talking about the alignment with the authorized ROEs that are presented here. I'm talking about the ROEs that I computed with the earned ROEs here.
Okay, but again, in each of these instances, the company's earned ROE is well below its authorized ROE, correct?
Yes, that's observed here.
Okay. Would you agree, Dr. Deepu, that in determining a revenue requirement for establishing rates, we apply the ROE that the commission authorizes to the rate base from the selected test year?
Yes,
Would you also agree that ROE modeling is intended to assess a reasonable ROE for the company to enable it to access capital during the period rates will be in effect?
yes,
Is that latter reason why you look at long-term growth rates to undertake your multi-stage DCF analysis?
yes,
And specifically use a long-term GDP growth rate as the third metric in your multi-stage DCF analysis. Is that right?
yes,
So for your DCF models, is it correct that you use stock prices as of December 31st, 2023?
I've used 3 candidates. That's one of them.
Okay, let's look at page 41 of, if we could go back to Dr. Deepu's answer testimony, please. Okay, so here you looked at in particular the closing price of the stock on December 31, 2023.
Yes, that's the first candidate.
Okay, and your and how much further into the future did you go than December 31, 2023 in calculating your DCF models?
I didn't get the question. How far in future?
Did you use data more recent than December 31, 2023?
Well, if you see the third candidate, which is the analyst estimation of fair market values, those are typically futuristic. And the expectation of these analysts can vary from 3 months to next 6 months or so.
Okay. So, but with respect to the closing price of the stock, that particular model, that was what, roughly 6 months before the date of your answer testimony? Is that right?
Yes,
And if we were to just, with that particular analysis, isn't it correct that if we were to update those stock prices just to June of 2024, all else equal, your DCF analysis would increase by roughly 45 basis points?
I'm not sure of the prices on June, so I can't say.
Okay. Another major difference between you and Ms. Bulkley in your DCF analyses is the growth rate selected. Is that correct?
Yes,
And you use a 3.80% rate, whereas both Ms. Bulkley and Mr. Fernandez for UCA used growth rates between 5.45 and 5.5%. Is that correct?
yes.
So if we turn to your answer testimony at page 39, you speak to concerns on line 4 through 7 about using long-term GDP growth rates as perpetual growth rates in view of the company's financial performance that does not appear consistent over the years. Is that right?
Yes,
But you still use the long-term GDP growth rates in your analysis.
yes.
Okay. So did you do a further calculation to determine what the outcome would be if we used updated stock prices to June 2024 and the same 5.45% long-term growth rate that Mr. Fernandez uses?
No,
So if Ms. Bulkley did that calculation and determined that the resulting average cost of equity would be 9.72% under your models, you'd have no basis to dispute that calculation?
well, with higher growth numbers for use for perpetuity, there would certainly be a higher outcome in terms of rate of return.
Yep.
So that
Okay.
is expected, but I don't agree with 5.44 being the long-term perpetual growth rate.
Understood. Okay. Last topic, Dr. Deepu. I'd like to talk briefly about your capital structure proposal. So if we could turn to page 54 of this testimony at table DD18 on that page. Here you identify debt to equity ratios of gas utility, which you call comparable companies. Is that right?
Yes,
And these are gas utility holding companies consolidated. Is that right?
these are the same companies which are used for ROE determination as well.
Okay. And for ROE determinations, we have to use the parent company or the consolidated company because that's who issues equity, right?
Yes,
And are you aware that public service issues its own debt?
yes,
Are you aware that public service has a standalone credit rating and credit metrics?
yes,
And public service company also has its own capital structure?
yes,
And if we were to use Xcel Energy's consolidated metrics for determining the ROE, we'd be looking at or for purposes of determining the capital structure, excuse me, we'd be looking at a comparable ROE of more than 10%.
I'm not sure if that's the correct statement, but I think what you're alluding to is the Excel's comparison to these 5 companies in gas utilities, which is not the case. These 5 utilities are comparable to PSCo.
Okay, and you're saying that because PSCo also has unregulated functions in your view?
Well, none of these have been contested as comparable company in your ROE estimation. These are the same companies that company witness Ms. Walkley also used.
Or Ms. Bulkley also used for ROE determining purposes,
Yes.
not for cap structure determination, correct?
In one of her annexures, she has done the average capital structure using the same companies, but with data from 2020 to 2022.
Oh, okay. So that's what you're referring to when you say the same as what Ms. Bulkley did?
Yes. Mhm.
Okay, but you
Yes.
don't come up with the same results, do you?
No, because the data that I have used is the recent one. It's the financial year ending 2023.
Okay. And Ms. Bulkley doesn't suggest using gas holding companies as the appropriate comparison, does she?
Well, she has it in her testimony and draws conclusions from that.
But that is not the basis for either her or Mr. Johnson's recommendation, simply showing the math, is it?
But she does suggest that based on the averages for these companies, the average, the range of 55% is okay.
Okay, but again,
That's my understanding of her testimony.
okay, your understanding, so at least with respect to Ms. Bulkley and Mr. Johnson, they are not suggesting that one should rely on consolidated holding companies as the singular basis to set a capital structure, are they?
Yes, perhaps.
I'm sorry, yes, they are, or
Yes, yes.
you think they are relying on that? Okay. All right, let's go back to your analysis, Dr. Deepu. In comparing to your utility holding companies here, you show PSCO at 0.855. Do you see that?
Yes.
Okay. And can you explain how that relates to an equity ratio when we talk in terms of 55 or 52 or 54% as opposed to the way you've shown it here in terms of 1.2 or 0.855?
So debt to equity ratio is, I can do the math or compute the formula. It's just when you add debt to equity, it will become the total capital. So by adding 1 to it and then taking the inverse, you can get equity ratio.
Okay. So it's your conclusion in looking at these analyses that if we turned back to page 53, in looking at what capital structure to recommend, you looked at these analytics. Is that right?
This is from company's response to the discovery question.
Okay. And you say on line 11 that these staff believes that these ratios indicate good financial health.
Yes.
Okay. And these ratios at the time that they were calculated are based on the company's current equity ratio of 55%. Is that correct?
Yes.
And they're based on the company's current ROE of 9.20% as calculated by the company. Is that right?
That's the authorized one. And
they're also based on the company's current inclusion of its directly observable cost of long-term and short-term debt in its WACC, correct?
yes.
And so going back to one of my earlier questions, Dr. Deepu, I don't see any calculation in your testimony of what these metrics would look like if staff's proposals were implemented and applied to public service going forward. Is that right?
Well, these are the actual numbers, so I can't recompute the actual numbers based on the current suggestions that or recommendations that I have for ROE. But for the credit rating metrics that Witness Johnson provided, I used my numbers, and that's provided as an attachment to my testimony.
Okay. And of course, these metrics, because they're based on actuals, also don't take into account the potential effects of implementing a 13-month average rate base or other adjustments proposed by staff going forward, correct?
These are just responses of companies' actual financial results. So I don't see that happening.
Okay. So it's really not possible to speak to the future financial health of the company if all of staff's recommendations or some portion of them were implemented in this case based on these metrics, is it?
there's the credit metric illustration that was provided to us by company witness Johnson, and I used the same mechanism to test it for my recommendation.
Okay, so you use these metrics to determine the company's current financial health, but looking ahead to try and test where the company's financial health might turn out, you looked at Mr. Johnson's metrics after you filed your answer testimony.
No, as part of my answer testimony, I have the same illustration that was used by company witness Johnson using my recommendation.
Okay. Thank you very much. I appreciate it. That's all I have for you today.
Thank you.
Thank you, Commissioner Plant. Any questions for Dr. DePia?
I have no type questions for Dr. Napu.
Commissioner Goman.
Afternoon. I also have no question.
You get a free ride, Dr. DePia. I guess from at least from the commissioners, Mr. Cox, any redirect?
Yeah, just a little bit of redirect. Thank you. Kind of start at the beginning there. You talked, do you remember talking with the company's counsel regarding the corrections that were made regarding the pre-tax or the tax shield? Do you recall that?
Yes.
And if you could, you certainly explained it a little bit, but if you could clarify a little around your explanation on why you didn't make a change to your particular testimony.
Yeah, I think I mentioned that the mechanism of computation of cost of capital is post-tax cost of debt and post-tax cost of equity weighted according to their ratios or proportions in the capital structure. That's an industry-wide practice, and typically that's what is understood by cost of capital by the investor community. So when the company chooses to mix a set of pre-tax numbers and one post-tax number, it doesn't reflect the real costs or returns that are approved by the commission. So I think it has signaling impact for ratepayers and investors and even other commissions which might consider the authorized rates of return by this commission. So I thought it would be good to align the nomenclature and the way cost of capital is computed based on what everyone else does.
And so would you say it was more of a nomenclature thing versus your actual numbers being different?
Yes, like I mentioned, the executable submitted with the direct testimony did not have a formula for interest computation in the revenue requirement, and therefore it led to a bit of confusion. But it was pointed out to us later that the number was inclusive of interest tax shield. So in terms of revenue requirement, it did not make any change, but in terms of nomenclature and syntax, it certainly is worth revisiting.
Thank you. And do you also recall talking about the differences between your analytical results and your final recommendations and the reconciliation of that?
Mm-hmm. Yes.
If you could kind of walk us through your thought process of how we get from the analytical results to your final recommendations.
Yes, I think to begin with, I would like to say that when I looked at this question of how much would be the fair and reasonable return, I found two sets of data which had very significant difference in the betas, equity betas. And Because of that, I actually took the step of computing betas myself to find which of these sets of data are more aligned with what I understand to be the true or the right methodology of computation of beta. So I started using that as the benchmark for selection of source of data points. And I have used SNP, and based on the SNP's betas, the returns on equity are in the range of, as mentioned in my testimony, 7.4 is the recommended one based on CAPM model. Then again, based on DCF models, I computed the rates of return, which are around 8.02. That's been the recommendation. But knowing that these rates are smaller than the currently authorized rates of return for the company, and well, it may be a bit of a speculation as to how the investor community might react, but I thought that there is a possibility of applying the philosophy of gradualism. So I've stated in my testimony that it is mathematically or statistically correct to use 8.02 or 7.4 to 8.02 numbers for ROE. But it might lead to a bit of shock to the system because it's relatively lower than even the currently authorized ROEs. So considering that aspect of rate making, I thought it would be good to move towards that direction in stepwise fashion. And I thought from 9.3 to perhaps 9 would be a good step to begin with.
And you mentioned your final recommendation. So you have the 9% as a point recommendation. You also have the range, which goes up to 9.25. Is that correct?
Yes.
And a 9.25 would still be within a range that's currently approved for public service. Is that correct?
Yes, that's right.
In talking about capital structure, you were referenced to the use of comparisons to the proxy group and Ms. Bulkley's comparison when she did her calculations. If we could we pull up hearing exhibit 102?
Sorry, it's just taking me a second to get there.
Sure. I'm looking at page 90. Lines 8 through 12. So Dr. Deepu, if you could read, you don't have to read out loud, if you could just read to yourself. Lines 8 through 12 there starts as shown in.
Yes.
Did you have a chance to read through that?
Yes.
Okay. So this is the equity ratios that Ms. Bulkley compared as a check to determine whether her proposed ratio, the company's proposed ratio matched up. Is that
Yes.
fair to say?
Yes.
Now, seeing those ranges, would staff's recommendation of 52%, would that fall within those ranges?
Yes, and I think I may not have represented the debt equity ratios in the way it is typically being described here, but the averages for gas utilities that I presented in my testimony is equivalent to 46% equity ratio. So in my testimony, I mentioned that the company's proposal is about 55%. What I computed from the comparable gas utility companies is 46%. So 50% would be something that would be in the midpoint. And like the ROE recommendation, I suggested that considering gradualism, we could move in that direction of moving from 55 to 50% over the next few years. And the first step would be to perhaps consider 52%, which still would be in the range of approved equity ratios currently in place.
Sure. Thank you. We can take this exhibit down. Just two more items. You also had a discussion about authorized versus earned, and you discussed, the alignment question. Do you recall that conversation?
Yes.
And I think the focus was on the difference between what was being authorized and what was being earned. But is it fair to say that it's not automatic that earned ROE will always be below authorized ROE?
Yes. I think it was discussed in the testimony of some of the company witnesses as well, that there have been observations that some companies have earned higher returns than those authorized by their respective commissions.
And the authorized ROE is the opportunity to earn that. Is that correct?
Yes.
Then last, I just want to revisit your table DD17. This is in hearing exhibit 402, page 53. And you were talking with company counsel about what this represents and potentially can't say exactly what it looks like in the future. But on lines 11 through 12, or line 11, and this was quoted, staff believes that these ratios indicate good financial health. So this would that line up in having good financial health with the current approved cost of capital in the last gas rate case?
Yes.
That is all my questions.
Thank you, Dr. Depew. You may be excused. Thank you, sir.
Thank you.
Mr. Hagland. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You want to put your hand down. Is anyone with you or communicating with you in any way?
No.
That changes, you'll let us know.
Yes.
Mr. Cox.
Good afternoon, Mr. Hagland. How are you?
Good afternoon. I'm good, thanks.
Could you please state and spell your name for the record?
Yes, my name is Eric Hagland. That's ERICHAGLAND. 24AL-0049G.
By whom are you employed and what is your title?
I'm employed by the Colorado Public Utilities Commission. I am the chief economist.
In this proceeding, did you cause to be filed answer testimony, including attachments, been marked as hearing exhibit 4403?
Yes.
And if I asked you the same questions that are contained in your answer testimony, would your answers be the same?
Yes.
Thank you, Chair. Mr. Haglund is available for cross and Commissioners' questions.
Ms. Herring, I have 30 minutes.
Thank you. Good afternoon, Mr. Haglund. My name is Valerie Herring, and I represent Public Service in this proceeding. You're
Good
doing well.
afternoon. I am, thanks.
Mr. Haglund, your answer testimony in this proceeding focuses on the company's proposed revenue stabilization mechanism, or RSM. Is that correct?
Yes.
And the company's proposed RSM is a full decoupling proposal for both residential and small commercial customer classes based on a total revenues approach. Is that correct?
Yes.
And if we can pull up your answer testimony, which is hearing exhibit 403. Yeah. And turning to page 9 of your answer testimony. And specifically, I'm going to draw your attention to lines 12 through 15. And here you contrast the company's current decoupling proposal with the company's decoupling proposal that was proposed as part of the company's last rate case. Is that correct?
Yes.
And you note that one of the differences is that the prior mechanism used a revenue per customer method, right? As opposed to the total revenue method we're proposing here, right?
Yes.
As the company's RSM is a full revenue decoupling mechanism based on total revenue as opposed to revenue per customer, you'd agree that this mechanism removes the incentive for the company to add customers to the system.
I don't know that I would say that it entirely removes that incentive. I think the company can still justify capital additions through adding customers to the system. So I don't know that it completely and entirely removes that incentive.
Understood. Not asking whether or not it entirely removes that incentive, but goes towards removing that incentive. You would agree with that?
The way I would put it is that the revenue per customer design encourages the company to add customers, and at least that incentive is addressed through a total revenues as opposed to a revenue per customer approach.
Understood. I think we have some agreement there. If we can pull up hearing exhibit 500, attachment 12, which is attachment 12 to Corey Skluzak's testimony. Mr. Haglund, do you recognize this document as the commission's order in the company's last gas rate case?
That's what it appears to be.
And if we can,
I don't recognize the decision number off the top of my head, but that's what it appears to be. Yeah.
Yeah, I would be afraid if you had memorized all the decision numbers. If we can turn to page 81 of this decision, please. And specifically, I'd like to call your attention to paragraph 279, which addresses the company's prior proposed decoupling mechanism. And here the commission concludes, quote, looking at the second line of that paragraph, a potential unintended consequence of HP 21-1238 is that revenue decoupling may cause a utility to focus its financial growth on maintaining and adding customers, which is shown by the record in the proceeding, further drives capacity investments in the system. Do you see that?
Yes, I see that.
So one of the concerns the commission had regarding the company's last decoupling proposal was that it could incentivize customer growth, correct?
That was one concern.
And you'd agree that the total revenue method proposed here for the RSM would better address that concern. You'd agree with that? Not obviously not completely, but better address it.
I would say that in terms of the incentive to add customers, the total revenues approach is an improvement upon the revenue per customer approach. Yes.
And if we can flip back to your answer testimony, hearing exhibit 403, let's look at page 8 of that testimony. And here at the top, you cite to House Bill 21-1238. Is that right?
Yes.
And setting aside the discussion about whether the company's current RSM proposal is predicated on the statute, you'd agree that this statute, as noted in the excerpt that you have here, encourages the commission to, quote, remove disincentives to the implementation of effective gas DSM programs, right?
I think that in the context of this bill, the language that's quoted here does refer to decoupling specifically in the context of removing the disincentive for conservation and BE. And in the commission decision that you just showed me from that previous rate case, the commission quite clearly indicated that they were interested in a decoupling mechanism that narrowly addressed the disincentive to promote conservation and beneficial electrification and not a broader type of decoupling.
Thank you. Mr. Haglund, are you generally familiar with the company's clean heat plan filing?
Yes.
In fact, you were a staff witness in that proceeding, right?
Yes.
And as a result, you're generally familiar that implementation of the company's clean heat plan is expected to result in significant reductions in gas sales for public service in the near future?
Yes. Although I would add that the company separately addressed the disincentive of the commission took a different approach to incentivizing beneficial electrification and conservation in the clean heat plan than it has done in its traditional DSM programs.
And I'm not going to get into the details of the clean heat plan with you. I just wanted to get your level set that both you and I agree that that plan will result in significant reductions in gas sales.
Yes, I agree with that.
And if we turn to your answer testimony at page 13, and specifically line 19, all the way at the bottom, and then continuing to page 14, here you testify that, quote, the long-term reductions in gas sales envisioned under many of the clean heat scenarios would make the current approach to cost recovery untenable. Is that your testimony?
Yes.
And turning to your answer testimony at page 13, lines 12 through 13. Sorry, page 13. I'm going back. Okay.
This is page 13.
Sorry, Yep. So turning to lines, there you talk about the company's current demand side management acknowledgement of lost revenues, or the DSM ALR. Is that right?
I'm sorry, I'm not seeing that on the screen.
I'm
Can you
not
point
seeing
me to
it
which line?
either. Just a second.
I'm sorry, that was page 14. You're right, page 13.
Okay, yes, there we are. So at lines 12 through 13, yes, in the middle of the page there. Do you see that now? And I can state the question again, that the company's, you're talking here about the company's current demand side management acknowledgement of lost revenues, or DSM ALR, correct?
Yes.
And if we could pull up hearing exhibit 171 from the company's box. And Mr. Haglund, does this appear to be an accurate copy of the company's tariff related to the company's DSM ALR?
I believe that this is the DSM tariff. I don't see the ALR referenced in these pages, but it's pretty small. Oh, okay, I see it there. Yes.
And if we could turn to the top of the page, on the final page of this exhibit, page 3. And I'm looking specifically here at number 8. It states and it's talking about the residential portion of the DSM ALR. It says the RDSM ALR value is the sum of multiplying the dollar per therm value as approved by the Commission for Residential Service times the annual number of therms lost from all residential programs executed during the program year under consideration. Do you see that?
Yes.
And so the calculation here for the DSM ALR is based on an annual amount. Is that correct?
Yes.
I'd move admission of hearing exhibit 171.
Any objection, Mr. Cox?
No objection.
So moved.
Mr. Hagelin, let's turn back to your answer testimony at page 13. Again, lines 12 through 13. And here you state that the current DSM ALR is likely not the best mechanism to relieve the upward pressure on rates going forward. Is that your testimony?
Yes.
And moving on to page 16 of your answer testimony. Here at lines 1 through 4, you highlight another issue with relying on the DSM ALR as you testify, quote, "It's currently unclear whether public service is authorized to use the DSM ALR for lost revenues associated with DSM activities funded by the company's Clean Heat Plan budget." Is that correct?
That's correct.
And it is also true that the current DSM ALR only removes disincentives associated with DSM programs, right?
Yes, that's correct.
And based on what we've discussed so far here today, it appears that staff agrees that given the expected future declines in gas sales and its corresponding upward pressure on rates, current approaches to cost recoveries, to use your words, are untenable and that something must change, right?
Well, in my testimony, I make a distinction between sort of near-term considerations and longer-term considerations. So in the near term, I think the DSM ALR is completely appropriate for removing the disincentive for conservation and BE measures. And in fact, I quote the company's filing saying exactly that the company considers it an effective way to remove the incentive or the disincentive for conservation and BE. So I think the company and I agree that in the short term, the DSM ALR fulfills this purpose that was the supposed objective of the company's proposed RSM. I do agree that in the longer term, there is a bigger consideration, a bigger question over how the commission is going to address the more significant lost revenues associated with sort of the longer term clean heat plan impacts. And I think the commission, rather than sort of on a partial record without a full consideration of all the options available to it should not approve the decoupling measure proposed here, but should have a wider range of options to choose from for that to address that longer term issue.
And Mr. Haglund, I think the company and staff have a disagreement about whether or not the current DSM ALR is sufficient mechanism in the short term, but setting that dispute aside, both staff and the company agree that in the long term that something needs to change.
I think the way that you and I just discussed is in the long term, I think existing approaches to cost recovery are untenable given the volume declines that we expect under clean heat. Yes.
And if we could move to page 17 of your answer testimony. And specifically lines 15 through 18. And here you testify that if the commission is interested in considering decoupling, that the commission should order the company to bring another proposal in either a future phase 2 rate case or a combined phase 1 or phase 2 rate case, correct?
Yes.
And you're generally aware that the company's targeting its next gas phase 2 rate case for the end of 25, excuse me.
I believe I heard Mr. Paquet say something about that when he was on the stand. Yes.
And given that timing, you'd agree that your proposal to delay implementation of a decoupling mechanism would result in a delay of at least 2 years. Does that seem reasonable?
I wouldn't speculate as to the timeline. It's possible that case could settle and it would be quite a bit less than that. I believe I heard Mr. Paquet say that the phase 2 was anticipated in 2025. I don't know that he said at the end of 2025. So I think there's a lot of uncertainty around what that timeline would be.
I think you and I can agree, though, that it would be a delay from whether or not a decoupling mechanism is instituted in this case.
Correct. But as I've testified, I think the DSM ALR is sufficient in the near term.
Let's turn to your answer testimony at page 14. And if we can scroll down to lines 13 through 16. Here you testify that staff's, quote, primary concern with the company's decoupling mechanism, or RSM, is it'll put rate increases on autopilot. Is that correct?
I think that the overall trend of rate pressure will be upward, and that the tendency of those quarterly filings will be increases, and that those quarterly filings are intended to be non-litigated proceedings. So it is likely to result in a series of quarterly filings that more frequently increase rates than decrease them.
And if we can pull up hearing exhibit 116, attachment JJP4, which is an attachment to company witness Paquet's testimony, direct testimony.
You said 116 JJP4?
Yes. Please. And Mr. Haglund, did you review this attachment to Mr. Paquet's testimony in developing your answer testimony?
Yes, I believe I did, but it was quite some time ago.
Understood. And at the bottom of this attachment, it outlines the different filings that the company will be making related to the RSM proposal. Do you see those?
Yes.
So, and this is just providing an example, but it shows 4 filings each year related to the company's RSM. Is that correct?
Yes.
And is it your understanding that these quarterly filings will be advice letter filings made on 30 days notice?
I believe they would have to be advice letter filings. I'm not sure about the notice.
Right, because they're instituting a rate change?
Yes, because they're changing the tariff.
Right. In other words, the time period between these filings and their effective date would afford staff, UCA, and other parties time to review the company's filings before those rates are changed?
I'm sorry, I apologize. My dog was barking and I missed the part of your question there. Could you repeat it, please?
Sure. Given the delay between the time that these quarterly filings are made and the time that the rates are implemented, that would give staff, UCA, and other parties time to review these filings and determine whether or not they want to protest the RSM.
It's true that parties would have the opportunity to review and protest, but generally with rate adjustment clauses, these are set up with the intention that they not be litigated because the delays to implementation caused by litigating them results in a lot of deferred balances and the need for true ups. And it's true that parties would have the ability to protest and ask for a hearing, but the expectation that will happen tends to be lower for rate adjustment clauses like this. And the point I'm trying to make with the not wanting to put the likely rate increases on autopilot, as I put into my testimony, is that it would be unlikely that parties would protest because such increases could follow the approved mechanism from this proceeding. I'm not disputing that the company would follow whatever mechanism was approved in this proceeding, so it may not justify a protest. What I'm saying is that the effect of these likely increases over time is significant, and I think the commission should, given the uncertainty around how quickly gas sales might decline and what impacts that's going to have on rates, I think the commission would be wise to keep this issue sort of in front of it, where it can really address these rate increases as they happen and not allow them to occur in the background little bit by little bit before being able to recognize that there's a problem.
So, Mr. Haglund, as you admitted, parties, UCA staff would all have the opportunity to review these filings and make a determination about whether or not they want to protest them, correct?
That's
it
true.
Wouldn't happen automatically. Okay. And the company's proposed RSM would also be subject to full review and adjustment in any future rate case, correct?
I would expect so, yes.
And this would include both future phase 1 and phase 2 rate cases, correct?
I'm not sure. It would definitely happen in phase 1 because the amount of total revenues that the RSM is designed to recover are determined in phase 1 cases. I suppose it would, to the extent it came up in phase 2 at all, I'm not sure that it would be a litigated issue because whatever class cost allocations result from a phase 2 rate case might just flow into the decoupling mechanism through a compliance filing. I'm not sure that would be a litigated issue.
Okay, but it could be an issue that's raised by parties in a phase 2 case. You'd agree with that?
It could be.
And you would agree that recently the company's been filing phase 2 rate cases on a fairly regular cadence, correct?
I'm not sure what you'd characterize
about every 2 years the company's been filing gas rate cases.
Phase one rate cases.
Phase one, sorry. You'd agree with that? And in addition to the quarterly filings and review in future rate cases, the commission could also order the company to file any other information it felt was necessary to monitor the implementation and effectiveness of the RSM, correct?
Yes, it could order that.
I have nothing further for this witness.
Commissioner Plant, any questions?
I do not have any questions.
Commissioner Goman?
Afternoon. I don't have any questions either.
Nor do I. Any redirect, Mr. Cox?
Yes, I do have some. Mr. Haglund, do you remember we looked at your answer testimony and specifically the portion that was talking about HB 21-1238 about removing incentives for DSM? Do you recall that?
Yes.
And when you were discussing that portion, you weren't providing a legal opinion, were you?
No.
And along those same lines, do you recall the conversation where you asked several questions about the current proposed decoupling mechanism, the RSM, and whether that RSM has removed the incentives for adding new customers?
Yes.
Can you tell us, are there other ways to discourage adding new customers to the company system?
Well, I would certainly point to the recommendation of Staff Witness O'Neill, which I'm sure will be discussed shortly, but I think that's a recommendation very explicitly targeted at removing the incentive to add new customers. So that would be the main one I would point to.
So decoupling, would you say is that's not the only way?
No, and I would point out that the company does not, that's not the reason that the company provides for making this proposal here. The rationale the company provides for making this proposal is to remove the disincentive for conservation and BE. As I've quoted the company in my testimony, the company has also explicitly stated that the DSM ALR effectively removes that disincentive. So in my view, the company's proposal does not accomplish anything additional in terms of removing that disincentive. It has the effect of shifting risk of under recovery from the company to ratepayers.
And you also recall talking about the clean heat plan, where you were asked if it will reduce sales for the company?
Yes.
And did the clean heat plan include incentives for the company?
It did. It allows the company to treat rebates for DSM and BE effectively like capital expenditures. It allows them to amortize those rebates over 4 years and collect and recover the unrecovered balance with interest at the company's WACC. So that was the incentive that the commission chose to approve for those rebates, which I think that's also a version of what the company proposed in that proceeding. So I think my recollection of that proceeding is that that was the incentive the company needed to be motivated to carry out those programs.
And how much of the rate increase for the clean heat plan was attributed to reduced gas sales?
According to the modeling that there were several iterations of the modeling in that proceeding. The model that the commission primarily relied on and references multiple times in its decision forecasts a 7% increase in gas rates. I believe this is by 2028. I'm sorry if I don't have that. The reference is accurate in my testimony. Only 1 percentage point of which is attributable to the decline in sales volumes.
And could you please expand on staff's position on what is best for the long term and short term to address cost recovery based on volume declines?
Well, I think the long term is a difficult question that the commission is going to have to put a lot of thought into and consider a wide range of options, because I think these clean heat plans are really trying something that hasn't been done for gas utilities anywhere. And so it's really it's an issue of first impression. Like many aspects of the clean heat plan, that this commission is going to have to be kind of a nation leading voice on what to do about that. And it's a really tough question, which is why I think the commission would be in a better position to consider its options if it had sort of a range of cost recovery options before it at the same time. So I've discussed, some of those options. One option is some version of revenue decoupling. There are rate design options. There are options that could involve using some of the electric utilities revenues to offset some gas revenues that are lost. And I would think that the company would be best positioned to weigh among those options and potentially combine them or choose one if all of those were presented at the same time. And I think that's why I don't approve or I don't recommend approval of the proposal in this proceeding. And also because I think in the near term, given the existence and the recent approval of the DSM ALR, the coupling is simply not necessary.
And do you recall when you were asked about the timing of the company's next phase 2 proceeding?
Yes.
And in your testimony, are you recommending that the phase 2 proceeding be sooner than towards the end of 2025?
I've made no recommendation about the timing of that, only that if the company wants to consider, or excuse me, if the commission wants to consider a decoupling proposal, it could order the company to bring a proposal back in a phase 2 or combined phase 1 and phase 2 proceeding that would better allow for it to consider decoupling alongside some of those other options I mentioned.
Are you aware of any other staff witnesses are recommending a sooner proceeding?
I am not.
Okay. Let's move on to kind of the last part. You were talking about quarterly filings. Do you recall that?
Yes.
How often does the commission suspend quarterly rate adjustments in your experience?
It's fairly rare. It's fairly rare that they're protested. So, as I was saying, I think the intent of those is to avoid litigation. And I think the line of question about the opportunity to protest those filings is it's different than the point I was trying to make in my testimony, which is not to suggest that those filings would be improper or that there would be something necessarily to protest about them, but that even if correctly implemented in accordance with the commission decision, that those filings would likely bring about an accumulation of small rate increases. And that generally, I think that rather than have a series of small rate increases happening in the background where they're not likely to get the kind of attention they'll get in a litigated rate case, it would be preferable to have them presented in a rate case where the commission can sort of consider the big picture.
And based on your experience, if the full decoupling is approved, would you expect the company to file less frequent rate cases?
I think that is one likely outcome, that I think both because of the declining sales volumes because of clean heat and DSM, but because the pressure on sales resulting from climate change is likely to be, it puts the company in a position that they're more likely to under recover because of warm winters than over recover because of cold winters. And I think that their full decoupling removes all the weather related risk of under recovery from the company. So that could have the effect of prolonging the period between rate cases.
Thank you, Mr. Haglund. No more questions.
Thank you, Mr. Haglund. You may be excused. I guess Commissioner Gilman, I think you and I had questions for Mr. Rivera-Lugo, but I think I got mine answered. Do you still have questions for Mr. Rivera-Lugo, or should we let him go?
I don't, but I didn't write down that public service waived their cross, so maybe I missed something.
Oh, did I get that wrong?
I show them with 45 minutes, but I'm not the official record keeper.
Did you waive your cross for Mr. Lugo or Rivera-Lugo, or did I get that wrong?
No, we had intended, commissioners, to waive our cross. We just needed to have a little bit of preliminary with Ms. O'Neill to confirm that. But we're quite sure we'll waive our cross of Mr. Rivera-Lugo as soon as that's done.
All right. So Mr. Rivera-Lugo, you may be free, but we'll keep you posted. So I guess we'll start with Ms. O'Neill tomorrow. Ms. Brahma, any final thoughts before we adjourn?
The only thought was whether it made some sense to have the preliminaries with Ms. O'Neill so that we get that out of the way. We can get Mr. Rivera-Lugo waived, but if the commission prefers tomorrow, that's just fine with us as well.
Oh, we can do that. I'll do that in a second. Commissioner Plant, Commissioner Gilman, I think you had an issue, Commissioner Plant.
Yeah, I'm gonna be out tomorrow, but I'll follow up with the recording and catch up.
That'd be great. All right, let's just bring Ms. O'Neill on for a few minutes. We're not going to try and finish her tonight. Ms. O'Neill, can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Is anybody with you or communicating with you in any way?
No,
That changes, will you let us know?
I will.
Ms. McLaughlin.
Yes, this will be very brief. But could you please state and spell your name for the record, Ms. O'Neill?
Yes, my name is Erin O'Neill. First name is Erin, E-R-I-N, and last name is O''N-E-I-L-L.
And by whom are you employed and in what capacity?
I am employed by the Colorado Public Utilities Commission as the Deputy Director of Fixed Utilities.
And did you cause to be filed what has been marked as Hearing Exhibit 401, Rev 1, the answer testimony of staff witness?
I'm sorry, you cut out for a minute, Ms. McLaughlin. Is that happening for anybody else?
I'm sorry.
Me too.
Okay, maybe I'll turn my video off and see if that helps with a little bit of the connection. Are you able to hear me?
Yes.
Okay, Ms. O'Neill, can you hear me?
Yes.
Okay, I'll state that again. Did you cause to be filed what has been marked as Hearing Exhibit 401, Rev 1, the answer testimony of staff witness O'Neill?
Yes.
And are you familiar with Hearing Exhibit 400, Rev 1, the answer testimony of staff witness Gabe Bregzibert?
Yes.
And are you adopting the answer testimony of staff witness Gabe Bregzibert?
Yes.
Now, if I were to ask you the questions in your answer testimony and the answer testimony of staff witness Gabe Bregzibert today, would your answers be the same?
They would.
And I have a couple of questions for you to help streamline one issue. This is what Ms. Bramo was discussing. This issue, the company and staff are a little bit more aligned than what was originally thought at the beginning of this hearing. Did you have a chance to listen to company witness Berman testify last week?
I did.
So you heard the questions that I asked of him related to net salvage and a depreciation study.
I did.
And you heard the answers he also gave in relation to net salvage and a depreciation study during the company's redirect of Mr. Berman.
Yes.
And what is staff's recommendation on these issues?
Staff's recommendation is that all the options regarding net salvage should be addressed in a standalone depreciation study. Staff is not recommending a change to the company's revenue requirement calculation or a change in net salvage methodology in this proceeding. Staff believes that the commission should have a full analysis of the different methodologies and the impacts of those, and that would be best accomplished through a standalone depreciation study. So staff recommends the commission order a depreciation study that presents different options for treatment of the net salvage value.
And does that align with the testimony you heard of Mr. Berman, which was provided last week?
Yes, I think Mr. Berman acknowledged that the staff, that the company was willing to provide such information to the commission.
I have no further questions on this issue, and I'm assuming that we will start the rest of the cross-examination tomorrow morning. But I wanted to make sure Ms. Brahma had the opportunity to see if that resolved the issues that we had.
Thank you, Commissioner Gilman. Any final, I think you're free, Ms. O'Neill, until tomorrow morning.
No, nothing additional.
Any final thoughts before we adjourn for the evening?
Nope.
The company will officially waive the cost of Mr. Rivera Lugo, so just thought we put that on the record at this time.
Thanks. See everybody tomorrow at 9.